Hello, everyone, and welcome to Uncivil Law. I am, as always, your host, and I'm happy to be here with yet another Supreme Court React. This time it is over the Dreamers, the DACA recipients, and whether or not they will be able to stay here or not. And so let me read the summary of the case. In 2012, the U.S. Department of Homeland Security adopted a program known as the Deferred Action for Childhood Arrivals, otherwise known as DACA, to postpone the deportation of undocumented immigrants who had been brought to the United States as children and to assign them work permits, allowing them to obtain Social Security numbers, pay taxes, and become part of mainstream society in the United States. In 2017, after the election, when the Trump administration replaced the Obama administration, the DHS began to phase out the DACA program. The parties do not dispute the authority of the new administration to replace old policies with new policies, but the plaintiffs in this and related challenges allege the new administration terminated DACA because of mistake of law rather than in compliance with law. Specifically, the Trump administration terminated DACA based on a conclusion that the administration had created DACA without proper statutory authority and with no established end date, and thus it was an unconstitutional exercise of authority by the executive branch. The plaintiffs in this case and related cases challenged this conclusion of law, alleging that rescission of DACA violated the Administrative Procedures Act because it was arbitrary and capricious, and because it was a substantive rule that did not comply with the APA's notice and comment requirements. The challengers also alleged that rescission deprived DACA recipients of constitutionally protected liberty and property interests without due process of law and violated the Equal Protection Clause because it was motivated by discriminatory animus. The United States Court of Appeals for the Ninth Circuit rejected the government's motion to dismiss for lack of jurisdiction, finding that the DACA rescission was not committed to an agency discretion by law and there was the law to apply. Further, the Ninth Circuit granted the preliminary injunction restoring DACA, finding plaintiffs were likely to win on the merits, they would suffer irreparable harm, the balance of equities tipped in their favor, and the injunction is in the public interest. The question presented is, 1. Is the Department of Homeland Security's decision to wind down DACA judicially reviewable? And 2. Is the decision to wind it down lawful? So that is the summary of the case. I'll give you a little bit about what I think on this in terms of some of the issues presented. So first issue was it lawful in the first place? My overall conclusion is most probably yes, it was. I read the DACA as a decision by the Obama administration to defer prosecution in these cases. The executive branch has prosecutorial discretion and they have the decision to defer prosecution by directing the DHS or any other agency that they so choose to not arrest or not follow certain cases, to commit their resources elsewhere, if you like. So I think it's properly best viewed as a exercise of prosecutorial discretion, in which case I think it is almost certainly legal. That being said, I would take note that since the President of the United States takes an oath to, among other things, protect and defend the laws of the United States, one could make a credible argument that this decision was a breach of that duty and therefore was an impeachable offense. But of course, Obama wasn't impeached over that, and so that issue is moot. But I think, one could possibly argue that conclusion, but that's of course not present here. The second question is, therefore, can the Trump administration undo this? My conclusion is probably yes. If you view what the Obama administration did as prosecutorial discretion, well, the different election means a different prosecutor, different chief prosecutor, and you can order those cases to be prosecuted once again. Does it need to go through a notice and comment period? My conclusion to that is no, probably not. This is an exercise of executive discretion. It is not changing the rule. So it's not changing the Code of Federal Regulation. It's not changing the statute. It's simply directing the agency to do one thing instead of another. So it's an executive order. And what the executive giveth, the executive can taketh away by the same process they put it in the first place. So because I don't view it as a rule-making procedure to do it in the first place, I don't think it's a rulemaking procedure to undo it either. So I think that if the Obama administration had the right to do it, the Trump administration had the right to undo it. Does their reason for doing it matter? Probably not, although I think it's a closer issue. If the executive has the authority to do this under a rational basis, which I think they probably do, then any reason will do, even if it's not a stated reason, is the typical rationale. So even though the Trump administration has been insisting they're doing this over and over and over again because it was illegal, I think ultimately that reason does not bind them. Any reason will do. Because we felt like it would fall into the category of lawful reasons if you view this as prosecutorial discretion. And so I think ultimately the rationale for why they did it is not binding because the level of review that would apply. And finally, can the courts hear this case at all? Probably not, is my conclusion. If you view this as prosecutorial discretion, that is an issue that is fully committed to the executive branch, and therefore it is not something that is judiciable. So therefore the Supreme Court would not have the power to review this because it is simply an exercise of executive authority. So that is sort of my tentative conclusions about what is going on here in terms of the law and procedures and how I think the legal issues are to be resolved. Evil Tribble says, is we're faithfully executing the laws of the land a good enough reason? Sure. I think if it's prosecutorial discretion, then, then their presence here is illegal. Therefore, we're going to continue to prosecute these cases. Seems like a perfectly reasonable reason to me. I mean, it's a violation of law and therefore can be prosecuted. And, again, what the executive giveth, the executive can taketh away. So again, another reason that perhaps Congress has given too much power to the president, but that is another discussion for another time. So, they keep giving power to the presidency, and, if you give power to them, well, that's one of the things they can do. So that is sort of my overall conclusions about this. So my feeling on this is that the United States Supreme Court is going to ultimately vacate the decision of the Ninth Circuit, say it was invalid, and therefore the DACA repeal can go forward without any further hindrance. So I think the DACA recipients are going to apologize. I think the DACA is going to, I think the Supreme Court is going to basically say the DACA recipients are out of luck. They were never guaranteed tomorrow, and, tomorrow has come, and so that's kind of the end of that. Can Congress give the president the power to give them more power? I'm not sure on the answer to your question. Can Congress give the president more power? Yes. That's Youngstown Steel, a very famous case on this issue called Youngstown Steel. Basically says that, there's a bare minimum of power the Constitution gives the president. Congress can't take that away. But where there is laws that give the president more power, Congress can do that. They can give more power. And as a general proposition, Congress has been giving the executive quite a bit of power over the years to do things through administrative procedures and regulations. So Congress has arguably let go of its role, and so that gives the president the power to do things like this. So blame Congress, I suppose. Not to mention the fact that, this is all kind of Congress's fault in the first place because they're the one that set up the immigration laws. So, they could fix this by passing a different immigration statute. But, that's asking too much. So, whatever. So, yes. Evil Tribble points out that prosecutorial discretion is an important check on the massive bulk of felonies. I tend to agree with you, and that is why I don't think that it's illegal for the president to do that. I do think, you could impeach it for a breach of duty, breach of oath. You take a law to faithfully execute. This law is not being faithfully executed. Congress can impeach. However, I think Congress can impeach because it's a Tuesday and they're bored if they're so inclined. But I think, you could make that argument. But obviously they didn't, so it's a moot issue. And, one of the arguments is that, the president went too far here where he did it for improper reasons, referring to Obama. that the Obama administration did it for improper reasons, or they went too far. They did it for, but I don't think there's such a thing as improper reasons. It seems to be something that's fully committed to the executive. And again, because we feel like it seems to be a legally valid reason. So, yeah. So we're going to listen to the arguments and see if anything I just said, if my mind has changed, because I haven't heard this argument, and, we will see if, see if I change my mind. So let's see what the court has to say, and we will get started with this.
We'll hear argument first this morning in Case 18-587, the Department of Homeland Security versus Regents of the University of California and the related cases. General Francisco.
Mr. Chief Justice, and may it please the Court. In 2017, the Fifth Circuit...
Sorry, I just noticed the text is a little off screen, so let me fix the text. We don't want you to miss anything. No, a little bit more. There we go. All right, let's start that over.
We'll hear argument first this morning in Case 18-587, the Department of Homeland Security versus Regents of the University of California and the related cases. General Francisco.
Mr. Chief Justice, and may it please the Court. In 2017, the Fifth Circuit held that DAPA and the expansion of DACA were likely unlawful, a judgment this Court affirmed by an equally divided court. In the face of those decisions, the Department of Homeland Security reasonably determined that it no longer wished to retain the DACA policy, based on its belief that the policy was illegal, its serious doubts about its illegality, and its general opposition to broad non-enforcement policies. That decision did not violate the APA for two reasons. First, it's not subject to judicial review. The rescission simply ended a previous non-enforcement policy whereby the department agreed to not enforce the INA against hundreds of thousands of illegal aliens. But the decision whether or not to enforce the law is committed to the agency's unreviewable discretion unless a statute restricts it. And nothing in the INA requires the department, a law enforcement agency, to not enforce the law. Second, the decision to end this non-enforcement policy was eminently reasonable. DACA was a temporary stopgap measure that on its face could be rescinded at any time, and the department's reasonable concerns about its legality and its general opposition to broad non-enforcement policies provided more than a reasonable basis for ending it. After all, an agency isn't required to push its legally dubious power to not enforce the law to its logical extreme, since it undermines confidence in the rule of law itself and it conflicts with the agency's law enforcement mission. I'd like to begin with the reviewability question. If the Attorney General were to say that he wasn't going to seek death penalty prosecutions because he thought the death penalty was unconstitutional, that would be immune from judicial review. And if a new Attorney General came in and reversed that policy because he believed that the death penalty was constitutional, that would likewise be immune from judicial review.
General Francisco, there's a strange element to your argument, because you're arguing this is a discretionary matter. It's not reviewable because it's committed to agency discretion. But on the other hand, you say the agency had no discretion because this program was illegal. In other words, the law requires you to drop DACA. So how can it be committed to your discretion when you're saying we have no discretion, this is an illegal program?
For two reasons, Your Honor. First, we put forward both legal and policy reasons for the rescission. So this case is on all fours with Cheney, where the FDA likewise put forth legal and policy reasons. Its principal argument was that it lacked jurisdiction to regulate state use of drugs in carrying out the death penalty. Its alternative argument was that even if it had the legal authority to do so, it wouldn't have exercised it. And this court found that that decision was committed to the agency's unreviewable discretion. Here, we are likewise making alternative legal and policy arguments.
So it sounds like he's arguing in the alternative. He's saying first, it had to be because it was illegal. Second of all, even if it wasn't illegal, we had the discretion to do it anyway. So he's arguing in the alternative, which is perfectly proper under the federal rules of civil procedure. You're allowed to make mutually inconsistent arguments. First of all, we had to. Second of all, we didn't have to, and we decided to do it. So you can argue both those things. So yeah, it works for me as an answer.
But secondly,
I'm sorry. Go ahead.
Well, I do well, I do the New York State Rifle and Pistols decision, almost certainly. Unless because I haven't looked at the calendar, but unless there's something more interesting that week, which being a Second Amendment enthusiast seems unlikely, almost certainly will I be doing the oral argument for that case. So yes, something to look forward to.
Secondly, even if we were making purely a legal argument, and we're not, but even if we were, review would be foreclosed by this court's decision in BLE. What the BLE case held was that if an action is committed to an agency's unreviewable discretion, then it doesn't matter what reason it gives for taking that action. It's still unreviewable. And the specific example this court provided in BLE was a prosecutor who decided not to indict for a purely legal reason. And the court indicated that that was still unreviewable because the underlying action, the enforcement discretion, was committed to the agency's unreviewable discretion. So here we think we win under Cheney, and we also think we win under BLE.
What if the Attorney General said he, in his exercise of prosecutorial discretion, was not going to enforce any of the immigration laws? Would that still be non-reviewable?
Your Honor, then I think that you might run into Cheney's exception for a complete abdication of authority. But there's a critical difference between that and this. Here, we are enforcing the law. You can understand why Congress or the courts might say that you can review a decision not to enforce the law. Congress, in fact, passes laws so they'll be enforced, and you can understand why it might restrict the government's ability to not enforce the law. Here, we are enforcing law, and it's very difficult to see why the Congress would ever pass a law, say that something is illegal, and then try to hamstring the government's ability to enforce it. That's why we think we clearly fall within the Cheney presumption that it's an exercise of an enforcement discretion, and we don't fall within the Cheney exception, which would apply where Congress itself restricts the discretion or where there's a potential complete abdication of enforcement authority, as Cheney made clear might also be an exception.
So basically what they're saying there is that there's prior case law which says two things. First, if you completely decide not to enforce any of the laws, that might be reviewable. So you might be able to enforce that through a writ of mandamus. And second of all, if Congress passes a statute which restricts the discretion in some way, saying, certain cases must be prosecuted and puts that in very, very clear language, that's also reviewable. So Congress, once again, could act and fix these problems. But again, that would be asking too much for Congress to do stuff.
Just to understand what you're saying, General, that would suggest that the original DACA is reviewable, but the rescission of DACA is not? In other words, are you suggesting that there's an asymmetry in what's reviewable, that they don't stand and fall together?
Yeah, there is, because there's a difference in the two policies. Both of them, to be clear, both of them fall within Cheney's presumption. Both of them reflect an exercise of enforcement discretion that are presumptively unreviewable. The question then is whether Congress has done anything to restrict that discretion. With respect to DACA, the case that this court had before it a couple of years ago, Texas argued that the INA actually restricted the agency's ability not to enforce the law. And you can certainly understand why Congress might try to hamstring the government's ability not to enforce the laws that it passes. And the Fifth Circuit agrees. So that fell within the Cheney exception to the presumption. Here, though, nobody on either side is arguing that the INA somehow restricts our ability to enforce the law. And it would be quite surprising if Congress were to pass a law that says something is illegal and then tries to somehow restrict the government's ability from enforcing the laws that it passes. So again, I think we fall foursquare within the Cheney presumption, and the Cheney exception doesn't apply. And that exception applies, that exception covers both where the statute itself restricts the discretion, and Chief Justice, Justice, to your question, it could also apply where there was a complete abdication of law enforcement responsibilities. That was one of the areas that Cheney reserved in that critical footnote 4. But here, we're not enforcing the law. We're enforcing the law, and there is simply nothing in the INA that somehow says to the Department of Homeland Security, you are restricted in any way or shape or form from enforcing the laws we pass.
The response that you gave to me, I didn't see. I thought that what do you call it, the Duke memorandum said DACA is illegal. I didn't see where it said whether it's illegal or not as a matter of administration policy. We are withdrawing.
Mm-hmm.
I didn't see that.
Yeah.
You said there were alternate arguments. I saw only the first. We can't enforce DACA. We can't adhere to DACA because it's illegal.
So 2 responses, Your Honor. First of all, Secretary Nielsen's memoranda clearly encompasses all of the different arguments. It sets them forth in great detail, and we think that the Nielsen memorandum is clearly properly before the court. The district court in Washington, D.C. specifically asked for it. We specifically provided it. The district court reviewed it. So the only question really is, what does it mean? And Secretary Nielsen, in her memorandum, effectively ratified Secretary Duke's decision for the reasons given, using precisely the same mechanism that Secretary Duke used herself to issue the memo in the first place, the same mechanism that was used to issue the DACA memo, and the same mechanism used to issue the DAPA memo. So this isn't a post hoc rationalization of agency action. It is agency action. The whole point of the post hoc rationalization rule is to prevent courts from invading into executive branch decision-making.
The point, and this is an old argument,
yeah.
And there have been 2 bases. The first base is a big argument between Ken Davis and Berger, and is it that you can't review an agency? Does that little thing about you cannot committed to agency discretion by law, does it mean that there are certain things an agency might do? Mm-hmm. Don't review them even if they're totally wrong, like Panama Canal tolls.
Right.
Okay. That isn't here, I don't think. The Cheney argument, I thought, was the reason this is unreviewable is because there's a long history and tradition of a prosecutor saying, I know that guy over there or that woman here, and they may be guilty, but in my discretion, no, I don't want to prosecute them. There's a long history of that. Mm-hmm. And if that history, an understandable power to give to a prosecutor, is to be valid, courts stay out of it. Now, that does not apply where what's at issue is not a prosecutor making an individualized decision, but rather an agency's policies,
right,
generalized, written down, and I can't think of a reason why in such a case you wouldn't review it in a court.
So respectfully, Your Honor, I strongly disagree because Cheney itself involved not a prosecutor but an agency and not a single-shot enforcement action but a general policy. Here's what the FDA said in the letter denying the petition brought by the inmates to have it regulate the state exercise of the death penalty. This is their principal conclusion. For the reasons given below, we conclude that the use of lethal injection by state penal systems is a practice over which FDA has no jurisdiction and therefore that FDA has no authority to take the actions your petition requests. Accordingly, your petition is denied. It later provided as the alternative rationale a policy rationale, and it says later, thus, as a secondary and separate basis of denial, we decline as a matter of enforcement discretion to pursue supplies of drugs under state control that will be used for execution by lethal injection. So in Cheney, the FDA clearly was announcing a categorical policy that it wasn't going to regulate the state use of drugs in carrying out the death penalty, and it wasn't to criminal prosecutions.
So, I mean, that seems like pretty good precedent to me, right? So they're pointing to a parallel situation with another agency, and let's say, look, the FDA said on the one hand, it's not legal for us to do this. On the other hand, even if it is, we're not going to anyway. And that was upheld. So Breyer's question is basically off point in light of this precedent. It said, yeah, this isn't an issue of prosecutorial discretion as such in terms of an individual prosecutor. It's an issue of an entire agency, but you guys said this was cool in FDA, so it should be cool now. So, yeah, I think, the precedent seems right to me. Seems like it's on point. Yeah, on the one hand, it's not legal. On the second hand, even if it is, we're not going to do it anyway. Seems pretty parallel to me. All right.
I think it's on all fours in favor of us. Here we have an exercise of enforcement discretion that is committed to the agency's unreviewable discretion under Cheney. It doesn't fall within any of the exceptions to Cheney where Congress either restricts the exercise of that discretion, because here we're talking about enforcement, not non-enforcement, and it doesn't fall under the complete abdication exception to Cheney because, again, we're talking about enforcement and not non-enforcement.
Wouldn't what you just read also have made DACA itself unreviewable, to pick up on Justice Kagan's question from earlier?
No, Your Honor, and again, because critically it falls within...
What's the distinction between DACA and the FDA policy?
The DACA and the FDA policy. Yeah. Well, because in the FDA policy, nobody was claiming that somehow a statute restricted the FDA's ability to not enforce the law. Nobody made that argument. In the DAPA litigation, I think is maybe what you're referencing, Texas specifically argued that the INA did, in fact, restrict the agency's authority to exercise its enforcement discretion to not enforce the law.
One of the things that Texas argued in the DAPA.
Evil Tribble said, what review could possibly be appropriate if a prosecutor simply won't bring a case? We need to bring a judgment on a non-existent case. It would be a writ of mandamus. It would be a court. You'd basically bring it as an in re. You bring it in re, whatever, and ask for the court to issue a writ of mandamus ordering the prosecutor to, bring the case. So that's how you would do it, technically. Yeah.
Case was that the agency action in question there conferred certain benefits on the individuals who were affected. And if that was sufficient to make that reviewable, does the wind down of DACA remove certain benefits that individuals would have? And
right.
If it does, would that make this reviewable?
I think the answer is no and no. And the reason why is, first of all, the rescission of DACA doesn't rescind any benefits. Those benefits are allowed to expire on their own terms. But even putting that aside, the work authorization and the other benefits are simply a collateral consequence of the exercise of prosecutorial discretion itself. So they don't make the prosecutorial discretion itself reviewable. Otherwise, every grant or denial of deferred action would be subject to APA review, because every grant and denial of deferred action has collateral consequences that impact work authorization. If I could give you a hypothetical that I think makes it more concrete. Suppose a prosecutor has a drug diversion program, and he says that I'm not going to prosecute this particular category of drug offenses if the individuals agree to enter into drug treatment. The drug treatment is a collateral consequence of and a benefit that flows from the prosecutorial decision, but it doesn't render the prosecutorial decision itself subject to review. And likewise, if a new prosecutor comes in and says, I don't like drug diversion programs, I want to have a zero tolerance policy for drug offenses, that isn't reviewable either. But I do think that the challenge to DAPA in the prior litigation was reviewable. To be clear, it was reviewable because it fell within the Cheney exception. Texas argued, the Fifth Circuit agreed, that the INA, in fact, restricted the Department of Homeland Security's ability to not enforce the law, and frankly, we agree with that. But the problem here is that there's no argument by anybody, or any possible argument that could be made, that somehow the INA restricts the Department of Homeland Security's authority to enforce the law. After all, Congress typically wants the executive branch to enforce the laws that it passes.
So there were two questions. Evil Coleslaw said, would that stop a prosecutor from bringing the case to trial and immediately resting with no real evidence or argument? Well, just because the prosecutor's office is ordered to bring it doesn't mean the prosecutor themselves would necessarily have to do it. There's ways for a prosecutor to say that they're conflicted out, and say that, that they are conflicted, and usually there's some discretionary in there for just basically any other reason. So, if they ordered the prosecutor to go ahead, prosecutor would say, basically conflict themselves out if they really didn't believe in the case. And then, by operational law, someone else would be appointed to prosecute the case. Usually there's a court hearing of some kind. A judge usually makes the appointment. So that's the way to solve that kind of problem. If a prosecutor didn't recuse themselves and did what you were suggesting, it would be in contempt of a writ of mandamus, so it'd be in contempt of court. So, among other things, they'd be facing criminal penalties of their own for being defying of a court. So the way for a prosecutor to solve that problem is to recuse themselves if they really don't think it's a case worth bringing in, let someone else do it for them. Someone asked, is not being prosecuted a benefit in and of itself? I would say no, it's not. I would say there's no security in not being prosecuted. A prosecutor might make a decision not to prosecute for all kinds of procedural and technical reasons, and those reasons may change. So just because they say you're in the clear today doesn't mean you're in the clear tomorrow. You could imagine, a lot of cases where that would be for pretty routine reasons. The police close a case, or the police refer a case, and the prosecutor thinks, oh, there's not enough evidence, and you get, wind of that, and they say, we're not going to prosecute this. And 2 years later, they find evidence that would lead to your prosecution. You can't hide behind the idea that, 2 years ago, they said, oh, we weren't going to prosecute. It's like, well, things changed, there's and a new DA gets elected and they have different priorities. It's like, there's no security in being told that they're going to exercise discretion in not prosecuting you. That discretion can change, and there's no, that's just the way it goes. So don't break laws, I guess, is my operative lesson here for the day.
Is this an appropriate moment to move to assuming reviewability, the merits?
Anytime you want to move there, Your Honor, I'll move there.
One argument that the other side makes along those lines is similar to this one we've just been considering, and the reliance interests that have grown up around DACA. And what do you say to that, and whether they've been adequately considered in this case?
Two things, Your Honor. First, I would say that to the extent there are any reliance interests, they're extremely limited. DACA was always meant to be a temporary stopgap measure that could be rescinded at any time, which is why it was only granted in 2-year increments. So I don't think anybody could have reasonably assumed that DACA was going to remain in effect in perpetuity. Even putting that to the side, here, the agency considered the reliance interest. Secretary Nielsen did so quite clearly and explicitly. The agency mitigated the reliance interest through the orderly wind down, and it simply concluded that beyond that it didn't justify maintaining in perpetuity a program that actively facilitated violations of the law by hundreds of thousands of individuals.
May I ask you? I'm sorry. No, continue.
Thank you. If I understand, though, your colleague's argument on the other side, it's not that Secretary Nielsen failed to consider reliance interests. There's that paragraph, I believe, in the petition appendix around 125, somewhere in there. There's a paragraph, but that given the extent of the reliance interests and the size of the class, more needed to be said, more could be said, and it wouldn't be a huge burden to require the government on remand to say more. As I understand that, that's the nature of the argument.
Right, and I guess I'd have a couple of responses to that. The first is that I don't think it reflects an accurate understanding of APA review. As this Court has repeatedly made clear, really the only thing that matters is whether the agency, and I think I'm quoting from the case law, completely failed to consider an important aspect of the question. And I don't think that you can even remotely argue here under State Farm that we completely failed to consider an important aspect of the question. Secondly, I think that Secretary Duke's memorandum under the proper standard clearly satisfies the APA standard for considering reliance interests. She does so explicitly in the portion of the memorandum that you referenced. And in addition, what I point out is that at the very beginning of her memorandum, page 2, she specifically says that one of the things that she considered were the judicial opinions reviewing the Duke memorandum, all of the district court decisions. And so then when she gets to the specific discussion of reliance interests, she says that she is keenly aware that people have ordered their lives in light of the DACA decision. So I think it's quite clear that she is fully taking into account the whole panoply of reliance interests that were discussed ad nauseum in the district court decisions and simply concluding that they didn't justify maintaining the policy.
I'd like to continue the same question because, look, the best statement of the law, in my mind, it's a very old principle again, was Justice Scalia's writing for the court in Fox. He says, when an agency's, quote, prior policy has engendered serious reliance interests, it must be taken into account. All right? That's this case, I think. All right. So I counted. I had my law clerks count, actually. Not just the people who came in, the 700,000, right. They've never been anywhere else. They never have to, but there are all kinds of reliance interests. I counted briefs in this court, as I'm sure you have, which state different kinds of reliance interests. There are 66 healthcare organizations. There are 3 labor unions. There are 210 educational associations. There are 6 military organizations. There are 3 home builders, 5 states plus those involved, 108, I think, municipalities and cities, 129 religious organizations, and 145 businesses. And they all list reliance interests, or most of them list reliance interests applicable to them, which are not quite the same. They're not quite the same as those of the 700,000 who have never seen any other country. And so then I did read what you just read to me. Now, you want to say anything about the statement you just read to me being adequate to take into account that broad range of interest?
It cannot possibly be the case that to take account of the reliance interest means you have to take into account each one of those as a separate line item and deal with them all independently. I mean, like, if that's what it meant, you could never get anything done because it would just be piling up and piling up and piling up. So, like, to me, that's like, why didn't you separately address these 400 separate things? I'm like, really? That's what we have to do. I mean, first of all, I don't really think all of them probably count as reliance interests. They probably dressed it up that way, but it's not really reliance interests. And so, like, and as the Solicitor General has pointed out, the program itself was only authorized for 2-year periods. How much reliance interest can you possibly have when it says, well, it could expire at any time after a 2-year period? It's like, how deep is your reliance interest possibly get? So it's like, I don't think that makes any sense to my mind.
Yes, Your Honor, I do. Because the first thing I want to say is that State Farm itself says, and here I've got the quote, you violate the APA only where you, quote, entirely fail to consider an important aspect of the problem. Here, Secretary Nielsen explicitly considered the reliance interest, including all of the things that you just listed that were set forth in excruciating detail in the numerous district court decisions that had ruled against us, which she says she specifically considered.
But not in her memo.
Well, Your Honor, I frankly think that she does. But the other thing that I would say is that under this conception of APA review, DACA and DAPA likewise would have failed arbitrary and capricious review because there is not a single word in the DACA memo itself or the DAPA memo itself explaining any of the potential costs or benefits or impacts on other people that the implementation of the DACA program would have had.
Good.
Go ahead.
I'll take either one, Your Honor.
If I understand Secretary Nielsen's memo correctly, Secretary Nielsen said that she did have a conclusory statement about weighing the reliance interests, but she weighs them against what she calls, I think it's the questionable legality of the program. Now, that assumes one of the things that we're all here to discuss, which is that the program was of questionable legality. If the program turns out not to be of questionable legality, in other words, if some or many of us think that the original program was legal, how does her memo suffice to do that balancing?
For a couple of reasons, Your Honor. First, because she sets forth separate and independent bases justifying the rescission. First, her belief that it's illegal. Second, her belief that there are serious doubts about its illegality. And third, her conclusion that as a matter of enforcement policy.
I did misspell SCOTUS in the title, didn't I? Well then, thank you, Jay Lastra for like pointing it out. Someone finally pointed out that I messed up the title. Hold on. There we go. All better now.
The Department of Homeland Security is against these kinds of broad-based non-enforcement decisions. Any one of those, as her memo explicitly says, is a separate and independent
in her
basis.
statement about reliance, she particularly...
Well, he was the first one I noticed, so he gets the credit, I guess, for being noticeable. So thanks for the rest of you for trying, I suppose.
says it outweighs this questionably legal program.
I think what she is saying here is that is that given that there are extremely limited reliance interests in the first place, any limited reliance interests that exist are outweighed by all of the different reasons that she has articulated as separate and independent grounds for rescinding DACA. I think that's the only fair way that you can read that memorandum.
I have always had some difficulty in understanding the illegality of DACA. DAPA I put aside because in DAPA there was actually a process for attaining a pathway to residency. And I saw the argument that what DAPA did was directly contrary to that path. Mm-hmm. But I don't see anything in the INA that takes away the discretion of the agency in ordering its enforcement policies.
Right.
We all know it has limited resources. It can't, even when it wants to, remove the vast majority of aliens we have here. And so I've always had some difficulty in understanding what's wrong with an agency saying we're going to prioritize our removals. And for those people, like the DACA people, who haven't committed crimes, who are lawfully employed, who are paying taxes, who pose no threat to our security, and there's a whole list of prerequisites. We're not going to exercise our limited resources to try to get rid of those people. I still have an impossible time. I know you're going to argue contrary to this.
Sure. So I guess I have three responses, Your Honor.
All right, but let me just finish my question, okay? So putting aside that, the Secretary, in giving these extra reasons, because none of this was in the Duke memo, and I thought basic administrative law is you look at what's first given to you, not what you add later. But assuming you ignore that, and even look at the Nielsen memo, I think my colleagues have rightly pointed there's a whole lot of reliance interests that weren't looked at, including the very current president, telling DACA eligible people that they were safe under him and that he would find a way to keep them here. And so he hasn't. And instead he's done this. And that, I think, has something to be considered before you rescind a policy.
Right.
I feel, and maybe it's my bias showing, but I feel like the left-hand side of the court's bias is showing more than usual today. It's like, maybe I'm biased, but he gave what seemed to me to be a perfectly cogent answer in terms of the precedent. It's like, well, there's this FDA case that says basically this, and the left-hand side of the court has been chastising the right-hand side of the court for ignoring an overruling precedent. So hypothetically, the left-hand side of the court should be in favor of this. And also, the left-hand side of the court typically likes to have government power, all things being equal. They tend to, believe in government power. So it feels like they're going out of their way to want this to be not proper. And it's like, you didn't consider the 400 positions. You didn't consider that Trump said one thing and then did another thing. It's like, come on, guys. It's like, really? So, maybe it's my bias showing, but I just feel like these arguments from the left-hand side of the bench are weak today. It's, especially in light of the specific precedent.
Not just saying, I'll give you 6 months to do it.
Right. So
to destroy your lives.
So
putting all of that aside, and I'm going to get to my question.
What'd she say? She said, to destroy your lives. Not just to say, I'll give you 6 months to do it, she said. And then she said, to destroy your lives. I mean, wow, that's a little bit of bias showing through. It's like, man, geez, that's not. It doesn't strike me as the most legally valid point I've ever seen in my life. It's like, you're going to destroy their lives. I mean, like, lest I point out that they are here against the law, and so like, they hypothetically shouldn't be entitled to anything here any more than any other country except the country in which they have citizenship. It's like, that's the only country that owes them anything. So it's like, man, I mean, again, it could be my bias showing through, but it just feels very weak to me.
And maybe we'd have an opportunity to hear the three answers.
Yeah. Well, don't forget the three. I know you won't. But really, where is all of this in the memo?
Sure,
where is all of this really considered and weighed? And where is the political decision made clearly that this is not about the law, this is about our choice to destroy life?
Well, geez, that's one hell of a way to frame it, isn't it, guys? I mean, this is not about the law, it's about our choice to destroy lives. I mean, man, oh Lord, that's a pretty, like, sharp, biased way to frame it. Like, man, oh man, it's about, we're making an active choice to destroy these lives. And like, man, geez, it's like, can you show your bias anymore, man? Come on, Lord. Yeah. This is a Supreme Court version of Think of the Children, pretty much, man. It's like, anyways, carrying on.
Yeah. So, Your Honor, 4 responses now. I think I've added one. The first one is that I think that the prior president couldn't, and hasn't made any kind of promise that.
No middle ground says framed. Is she wrong? ICE raids DACA in fear every day. You shouldn't misunderstand the word framed by itself. This is a neutral word. It's not framed in the sense of like framing someone for a crime. That implies like bad action. When you talk about framing an issue, that is a neutral term. It's basically the scaffolding upon which you are going to analyze things. So it's like, you do this in your own life every day. Someone comes up to you in your own life and says something. Depending on like what frame you're in, like you're at work, you're in, your home life, it's your wife saying it, your kids saying it, it's just, different frames encourage different outcomes. So when you say, well, this is how I'm framing the argument, it's how I'm creating the scaffolding on which I'm going to put other things on. So the term frame is a neutral word. It just implies the way that facts are going to be interpreted against a backdrops, if you like. So you shouldn't be misunderstanding that. And as to like, framing is painting a picture. Yeah, exactly. So as to like whether these people fear arrest or prosecution, well, I mean, like, to the extent they're breaking the law, like every criminal should, in principle, like fear that. That's general deterrence theory. One of the reasons that you punish people, among other reasons, is general deterrence. The fear of, things coming after you. So it's general deterrence theory. It's like, yeah, maybe they do live in fear, but maybe that's not a bad thing because they're in violation of law. Now, whether or not the law should be changed is a wholly separate discussion, but if they're in violation of law, then they're in violation of law. So their fear is, you don't have any sort of interest in not being afraid of being prosecuted if you're in violation of the law, whether it's our country or someone else's. It's like, that's one of the things law does. So that's what I said. And as to the intent element, Ewan Marshall, not all crimes necessarily have an intent element. and they do have an intent at least to remain here. So, like, whether or not they came here illegally in the first place with intent, they're remaining with intent because all these people are, you know, old enough mind, as far as I understand it. And maybe that's not 100% true, but I understand that, like, all these people are of, you know, old enough mind to, you know, have the requisite intent to be continuing to violate the rules. So there's intent there in the continuing presence in the United States. So, you know, there's that.
DACA would remain in effect in perpetuity because it would have been impossible to make that promise. In fact, every one of my friends on the other side, I think, has agreed that we could rescind DACA at any time if, at least in their view, we did provide a little bit more detailed of an explanation. So I think that is foursquare against the notion that there's some significant reliance interest, because all that they seem to be saying is we have to write a few more words. Putting that entirely to the side and turning to the legality question, ultimately, I don't think my first point is I don't think you have to decide ultimately whether DACA is legal or illegal, because I think the other reasons we've given are more than sufficient to justify the rescission, both our serious doubts about its legality as well as our general opposition to broad-based non-enforcement policies. After all, the Department of Homeland Security is a law enforcement agency, and a law enforcement agency doesn't have to push its dubious power to not enforce the law to its logical extreme.
But don't you have to set up some kind of categories? I mean, everybody agrees, what is that, how many, 11 million people?
Right.
They don't have the resources, so you have to prioritize. Everybody agrees you have to.
Absolutely, Your Honor.
How do you do it other than categorically?
Well, and that's my second point, Your Honor. My second point is that DACA goes far beyond simply diverting resources to higher priority targets, which you are absolutely right. Every law enforcement agency has to divert resources to higher priority targets. DACA goes materially further than that because it actively facilitates violations of the law by providing advanced forbearance, coupling it with affirmative benefits like work authorization and Social Security benefits, doing it on a categorical basis, and significantly, and this was my third point, it has no limiting principle.
So the forbearance would be okay if there weren't attendant benefits. We're not going to immediately deport the dreamers, period.
I think that would be, if you provided just the advanced forbearance, I think that would be a lot closer of a question. But here it's a lot easier because you're coupling that with work authorization. And my final and critical point is that there's no limiting principle. The theory on which DACA rests effectively allows the government to create a shadow INA for any category of aliens that it chooses to make low priority targets, a shadow second tier INA. And you at very least need to locate something in the INA that confers that kind of broad and unfettered discretion, and there's simply nothing there. But again, I don't think
the INA does give quite a lot of discretion to administrative officers, as you yourself admit and have argued on previous occasions, and indeed in part here. So, are you saying that DACA was violated? Any particular provision of the INA? What are you saying it violated? Because there's a big delegation, right, that says you get to make national policy. So what did DACA violate?
I'm saying two things, Your Honor. First, I'm saying you don't really have to address this issue because we think all of the other reasons are more than sufficient. But secondly, we're not saying that there's a specific provision that it conflicts with, but what we are saying is that when you adopt this kind of broad and historically unprecedented program, you need to at least locate the authority to do so somewhere in the INA.
Well, they located the authority in the INA's grant of broad discretion over national immigration enforcement policy.
Your Honor, I think that the most that does is it gives you the authority to set policies and priorities. But there's a big leap between that and saying that you can affirmatively facilitate violations of the INA by hundreds of thousands of individuals to whom Congress has repeatedly declined a pathway to lawful status. Again, though, I don't think this is an issue you need to ultimately resolve, because I think the other reasons we've given for rescinding DACA are more than sufficient to justify it, including our serious doubts about its legality alone. Simply as a matter of law enforcement policy, it is eminently perfectly reasonable for a law enforcement agency to say, I'm not going to push this doubtful authority to its logical extreme when it does three things. It undermines confidence in the rule of law itself, it conflicts with the agency's law enforcement mission, and in a case like this, it creates the serious possibility of a court-ordered shutdown of the program rather than an orderly wind-down within the agency's control.
If DACA was illegal, that means that when the government was giving out these benefits, it was acting illegally, right?
Yes.
Now, it's not always the case when the government acts illegally in a way that affects other people that we go back and untangle all of the consequences of that. Did Secretary Nielsen, when she was considering the reliance interest, was she looking simply to the question of a wind-down, or was she looking more generally, for example, to the application of something like the de facto officer doctrine?
Right. I think
officers acted illegally, but we don't go back and invalidate their prior actions.
I think both, Your Honor. Both. The orderly wind-down, to a certain extent, takes into account reliance interest. It doesn't fully account for everything, but the whole idea was that you're giving people an opportunity to order their lives in a time period to allow them to do that. But she also specifically states in the memorandum that, in addition, the notion of ad hoc deferred action will be able to take care of reliance interests in truly extraordinary circumstances, the way that it has been used sporadically in the past to address those types of scenarios.
So now the basic Hornbook rule, we have three Hornbook rules in this case, is was mentioned, Chenery. It is a foundational principle of administrative law that a court may uphold agency action only on the grounds that the agency invoked when it took the action.
Right.
In which case we look to Ms. Duke's memo, not to Ms. Nielsen's. Isn't that when it took the action? And if so, I want to hear you say no, it isn't so. But if so, why don't we just affirm the district court, which sends it back? And if you have all these reasons and you really want to consider the reliance and all those things should be considered carefully, you can do it. So what's wrong?
For two related reasons, Your Honor. First, sending it back would make no sense because the agency has already acted. Secretary Nielsen has already ratified Secretary Duke's decision for the reasons set forth in her memorandum. It's not a post hoc rationalization. It's the official position of the agency set forth by the agency itself. And secondly, there is no reason why Secretary Nielsen should have had to reinstate DACA and then rescind it again.
Not reinstate it. Well, but what you do is, as there are 50 cases on this, if it's important, what you do is you say there's good reason for holding the status quo until we can go back, and courts have affirmed that. We hold the status quo, and we go back now and we look if there are reasons beyond the contemporaneous reason, which is the Duke memo, and we see.
That's precisely what Secretary Nielsen's memo did. It did two things. First, it explained the basis for Secretary Duke's decision, but secondly, it set forth her own independent judgment. And if I could,
we have all these 350 briefs with all these different reasons, and she had that in front of her.
Your Honor, that may go to whether you think her memo is sufficient, but it doesn't go to whether you think her memo is an operative document in this litigation. I'd like to point you to two places in her memorandum. First, page 121A of the Regents Petitioner's Appendix. This is the second page of her memorandum. The explanation reflects, the first thing, my understanding of the Duke memorandum, and, second thing, why the decision to rescind the DACA policy was and remains sound. If you look at the end of her memorandum, she states in the very last sentence, for these reasons in setting DHS enforcement policies and priorities, I concur with and decline to disturb Acting Secretary Duke's decisions to rescind the DACA policy.
Can I pick up on Justice Kagan's question earlier? Does the Nielsen memo ever say, even if DACA was lawful, I would still exercise my policy discretion to discontinue?
Yes, Your Honor. So if you look at the memo.
What sentence are you looking at?
I'm looking at two sentences. Page 123A. This is after she says it's illegal. Page 123A. Second, regardless of whether the DACA policy is ultimately illegal, it was appropriately rescinded by the DHS because there are, at a minimum, serious doubts about its legality. May I make one more sentence? And then third, if you look further down the page, it says, regardless of whether these concerns about the DACA policy render it illegal or legally questionable, there are sound reasons of enforcement policy to rescind the DACA policy.
Thank you, counsel.
Well, yeah, no, this is probably going to my bias as much as anything else, and at least I'd like to, admit my bias, so you can shade things appropriately in my analysis. But, for me, that argument seems perfectly sound. It's like, yeah, we thought it was questionable, we did it because of policy reasons, and like the questions, the left-hand side of the bench seem a little bit nonsensical. It's like, you didn't consider enough. I mean, this memo went on for hundreds of pages. It's like they considered a lot of things. It was detailed. It's like, it's like, oh, you had to consider all these things. We have so many briefs and there's so many points. You got to consider each one independently and like all these things. I'm like, and not in light of the precedent. It just doesn't make sense. It's like, yeah, I think the Solicitor General's argument was basically right. I think that this is something they can do. It seemed reasonably sound. So far, I'm still pretty much where I was at the start of the stream, so let's carry on. And I agree with Evil Tribble, where like the left-hand side of the bench was getting so buried in minutia about like how things are done. Now, like, procedure and process are important. So like, I don't want this to be like procedure and process are not important. They are important. Things have to be done in a particular way, but it seemed to me more minutia and like grasping at straws than anything really substantive. Like there was some major problem. It like the conclusion they want. It seemed like they're reasoning from the conclusion they want to get to, rather than like reasoning from the precedents. Like they, think the SCOTUS version of think of the children, and so they're looking for an excuse to do it. And so I just was not buying what the left hand side of the bench was selling today. And so I thought the Solicitor General's argument was basically right. But let's carry on with what Theodore Olson has to say.
Mr. Olson?
Thank you, Mr. Chief Justice, and may it please the Court. The government's termination of DACA triggered abrupt, tangible, adverse consequences and substantial disruptions in the lives of 700,000 individuals, their families, employers, communities, and armed forces. That decision required the government to provide an accurate, reasoned, rational, and legally sound explanation. It utterly failed to do so, asserting only the Attorney General's unexplained assertion that he had no discretion because DACA was an unconstitutional exercise of authority by the executive branch. The decision overturned a 5-year enforcement policy of deferred action that had enabled DACA recipients under other unchallenged laws and regulations to apply for employment authorization, seek driver's licenses, and other benefits. Its abrupt reversal removed a conditioned precedent to these rights and exposed DACA recipients and their employers to immediate, potential, coercive government measures. It was impermissible to do so based on an unexplained, unsupported, and erroneous legal conclusion that the policy that 2 administrations had enforced and implemented, had supported and implemented for 5 years, was unlawful and unconstitutional. The decision to rescind DACA was reviewable. This Court has said several times just in the past few years that we start with a strong presumption of reviewability of agency decisions. This is the strong presumption that the Court described in the Weyerhaeuser case just 1 year ago. Unless agency discretion is limited by law, and there's no citation to any limitation in the law, limitations on reviewability by the courts are quite narrowly construed, and there are rare circumstances. These are the mock mining case and a Judelang case. These Weyerhaeuser, mock mining, and Judelang case are 3 cases within the past 8 years where this court has talked about the presumption of reviewability as a strong presumption, exceptions narrowly construed, and all 3 of those decisions were unanimous decisions by this court.
Like, is anyone at any point going to mention Chevron or Brand X, cases which I utterly loathe and wish would die in a fire? But that being the case, they are still like the rule of law of the land at this point. Sure, agency discretions are reviewable by a court. No one disputes that. Under what standard? Chevron, which basically says, sure, anything the agency does is totally fine and totally cool. We have no problem with this. So, like, how can you review this action under Chevron and Brand X? Chevron says the agency gets to do whatever the hell it wants. Brand X says it gets to change its mind and reverse course at any time, and that's totally cool. So, like, how can you review this under Chevron and Brand X and say, yeah, sure, you can review the agency discretion, it's just that they can never be wrong? I mean, I'm slightly hyperbolic here. That's not quite what Chevron says, but close enough for our purposes, right? So, like, anyone going to mention Chevron and Brand X at any point, it's like, sure, you can review the agency for all the good it will do you. If you guys want to overturn Chevron and Brand X, that'll be fine. You know, so I'm just saying, I would love this case to die in a fire, but since it's the law of the land, it's like, anyone going to bring that up? The agency interpreted the immigration statute. It's the immigration agency. They're interpreting the relevant statutes. So how can they be wrong? So, yeah, carrying on.
You say that whenever a law enforcement agency has guidelines for the exercise of prosecutorial discretion and it then tightens those guidelines so that cases that previously would not have been prosecuted may now be prosecuted, that is agency action that is subject to review under the APA.
I would not say that, Justice Alito, but this is a very, very different circumstance. This is an agency decision initially. And the Attorney General refers to it as an illegal decision, but it's an initial decision that is responsive to explicit congressional direction to DHS to establish enforcement priorities. That's what DACA was all about. It said it did not establish any status. It did not provide any benefits. It articulated an enforcement priority, which Congress not only directed DHS to make, but in fact required it to make, because only 400,000 people out of
I'm not sure that really responds to my question. So I'll give you an example. Let's say that that there is a policy that a certain category of drug cases will not be prosecuted in federal court. Let's say they are cases involving less than 5 kilos of cocaine. So cocaine cases with lesser amounts of drugs will not be prosecuted in federal court as a matter of enforcement priority, and then that is changed. So the 5 kilos is reduced to 3. Would that be reviewable?
No, I don't think it would.
What's the difference?
Well, I think that the Justice Department, through the Attorney General, every new Attorney General establishes new enforcement priorities with respect to pornography or drug cases or things like that. That's completely different than this, which singled out a category of persons and, pursuant to congressional authorization, invited them into the program, provided other statutes which have not been challenged by the government, provided benefits that were associated with that decision, and other people and individuals relied upon that for 5 years. The administration, when it does that kind of a decision with respect to the lives of hundreds of thousands of people, which has engendered reliance, which reverses not only a position of two administrations, but the Office of Legal Counsel changes policy, then all we're saying is that there's a presumption of reviewability of that decision.
But you're saying it's reviewable because DACA conferred certain benefits.
DACA did not confer.
Beyond deferred prosecution.
DACA,
is that what you just said?
DACA, no, I said the benefits were triggered by the decision of enforcement policy in DACA, but those benefits are triggered by other statutes enacted by Congress, funded by Congress throughout all this entire period of time, and the government hasn't challenged those. So those benefits, the driver's license business and the work authorization, if you apply for it, if you come forward, identify yourself, put yourself into the program, take risks.
But Mr. Olson, the whole thing was about the work authorization and these other benefits. Both administrations have said they're not going to deport the people. So the deferred prosecution or deferred deportation, that's not what the focus of the policy was. Yes, the other statutes provided that, but it was triggered by the memo. So I don't understand sort of putting what the policy really was about, which is the work authorization and the other things, off to one side. Is very helpful.
Well, I think that one has to focus on the fact that this was Congress authorized the Department of Homeland Security to identify enforcement priorities. Once it did, because it was required to do so, and it had no choice because of the funding. Once it did so, and it identified the persons, and this is helpful to the agents in the field to identify which individuals are going to be subject to enforcement and which individuals are not. Other statutes provided that benefit. You're correct that it triggers that, but it's triggered by other benefits and so forth. If the government is opposed to those benefits given to individuals who are not in an enforcement priority category to support themselves, to go to work, rather than put themselves in the hands of the government to support them, and to become a part, since they're not going to be deported, at least for the short period of time, those are the things that if the government wanted to get rid of, the government should be challenging those. It should not be challenging a decision that's essentially required by Congress. And let there be no mistake about why this decision was made. The Attorney General specifically said that DACA was illegal and unconstitutional. I don't know where the unconstitutional came from because it didn't come from the Fifth Circuit. But let's say it was an illegal enforcement priority. And there's no doubt about why this happened. In the cert petition, or in the government's brief that refers to the questions presented, it specifically says the original DACA policy was unlawful, and then goes on to say, thus, it had to be terminated. There's no question about that. So the Duke Memorandum, which was the Attorney General's decision and opinion under statute, is enforceable and binding on the government agencies. There's a statute that specifically says that. So the Duke Memorandum had no discretion, no choice. The Attorney General of the United States...
Mr. Olson, I think you've moved on to the merits, and I guess I'm still struggling with Justice Alito's question on reviewability. Can you help me understand what is the limiting principle? I hear a lot of facts, sympathetic facts you put out there, and they speak to all of us. But what's the limiting principle between, you say, reviewability here for an enforcement, a classic kind of prosecutorial discretion that one might have thought would have fallen under Heckler versus Cheney, and the example Justice Alito gave, or Heckler versus Cheney itself?
Heckler,
what's the limiting legal principle?
Well,
you have this court
it's a composite. In this case, it's a composite of principles, a determination, that a categorical determination involving a substantial number of people to take decisions based upon that.
All right.
That's not really a really great answer in terms of a limiting principle. It's a little loose as a limiting principle, like policy that involves a substantial number of people. It's like, what qualifies as a substantial number of people? It's like, it's too floaty for much of a limiting principle, at least to me.
Let me just stop you there, though, because if it's categorical and a large number of people, I can think of a lot of prosecutorial decisions involving drug cases, the treatment of marijuana in our society today under federal law. Perhaps it would be cocaine, 5 kilograms. Whatever's in the Attorney General memo affects lots of people on a categorical basis every day.
Yes.
And you I think, would not have us review those decisions.
No, But may I refer to...
so if it's not categorical and it's not a large number of people, what's the limiting principle?
As I said, it's a combination of factors which include the government inviting people to rely upon and make decisions based upon that policy, the provision of benefits connected with it, individuals making choices, and the Heckler case...
Don't other people rely...
First of all, thank you, Brigadan 231, for joining us. Your presence was appreciated, and your absence will be missed. Second of all, I continue with, this is just way too floaty for me. It's like, oh, it's categorical. And he said, well, here's a categorical rule. And he said, would you review that? No, so it's not categorical. So what is it? It's a combination of factors, combination of lots of really important factors reaching complex stuff. It's like, what's the answer again? It's like, what's the limiting principle here? You know, how do we know when we've crossed the line? It's like, when it's complex and reaches lots of stuff, it's like, what? So we need a little bit more. And yes, and for those of you curious, today's beer is Von Trapp, which is from the family that inspired The Sound of Music. This is Von Trapp Double IPL, India Pale Lager. A little bit of Austria, a lot of Vermont. So, very, very tasty. Recommended for all you people out there who stuff. Not too bitter. Very, very nice. Van Trapp Brewing. So, that's what I'm drinking today. Let's carry on with the stream.
On the Attorney General guidance memos and documents, there's an entire industry in a lot of states involving marijuana that would argue they're relying on memos issued by the Attorney General that we will not enforce marijuana laws, for example. Do they now have a right to?
No, I think that's completely different. They are not invited to participate in a program, to reveal the business that they're in, to come forward, to take advantage.
Well, they have a lot
of
benefits. Of economic interest at stake that I think under Fox and what we heard about earlier from Justice Breyer, they would say our economic interests are very real. Billions of dollars are at stake. We've relied on the Attorney General's guidance memos.
And I just would like to quote this one paragraph or one sentence from the Heckler versus Cheney decision itself. When an agency does act to enforce, that action itself provides a focus for judicial review because it imposes the coercive power of the government with respect to individual liberty and property. And that is the kind of decision that judicial review is intended.
Doesn't every prosecutorial decision affect individual liberty or property? I think the answer is yes, isn't it?
Prosecutorial decisions, yes, of course. This is an announcement of a policy. This is a reversal of a policy that the government created that triggered, to use the words of this court, engendered reliance interests. And all we're saying is that it should be subject to review in the context.
I just fundamentally don't buy it. I just don't think there's any reliance interest really at all in a prosecutor's memo that says we're not prosecuting this. It's like, it's illegal. There's a statute that says it's illegal. The prosecutor is saying we're not going to enforce it for whatever reasons. I just don't see the reliance interest personally. It's like, you know, the prosecutor has discretion and new prosecutor comes in, they change their mind, there's political pressure, a whole bunch of reasons. I just, you could make a credible argument at least as to like crimes in the past, right? So like during this period where it was not being prosecuted, you could make like the 5 kilograms of cocaine, which for some reason has become the example we're going to. So I will stick with that. So like from the time they announced we're not going to prosecute for less than 5 kilograms of cocaine, which incidentally is quite a lot of cocaine. So this is a very generous policy. But from the time they announced that to the time they rescind it, like anything that happens in the interim, you could argue there was a reliance interest because like, you know, you relied on the fact that it wasn't being prosecuted. But if the prosecutor comes forward and says, well, from this date forward, we're going to prosecute anything further going on, then you could. And like the problem with, of course, illegal immigration is that they're in continuing violation of the law. So like, I just don't think there's any, you know, reliance interest, you know, in like the same way as you as a drug dealer, if you set up your enterprise for your 4.9 kilogram limit, you know, and everything's set up for that, and then the prosecutor changes one day, I don't think you can hide behind but it will be really inconvenient for my enterprise. rationale as to why they can't prosecute you. So I just personally am not buying that. So that's kind of where I'm sitting. But let's carry on.
Of this big picture. It isn't say that every decision by a prosecutor that I'm going to now enforce murder cases or kidnapping cases or child porn case or serious drug cases doesn't cause individuals to come forward to participate in a program, to make decisions. Businesses, health, educational institutions, the armed forces, all are making decisions based upon this. No one was saying that the policy can't be changed. But when the policy does, if the government wishes to change a broad policy like this, which affects so many people in so many serious ways.
Well, if I might ask a question about that, if we're talking about the merits then, and then I'll pass off the baton. The reliance interests that we've talked about earlier. I think your friend on the other side would say we did address reliance interests in a paragraph, and we could do it in 15 pages. But we'd say pretty much the same thing at the end of the day, and it'd take another 6 years, and it would leave this class of persons under a continuing cloud of uncertainty and continued stasis in the political branches because they would not have a baseline rule of decision from this court still on this issue.
It's what this court has said.
What do you say to that? What do you say to that? I mean, that's the line of argument as I understand it from the government.
Yes, I know it is. And the government's saying all we needed was a few more words. That is not what this court has said with respect to administrative review of judicial review of administrative decisions. You must have a rational explanation. It must make sense. It must be contemporaneous. I will get to the Nielsen memorandum, which was not contemporaneous. It was not a new decision.
I understand that. If you could just address it, though, on the merits. Why was that insufficient, I think, is one of the questions. And the other is, what good would another 5 years of litigation over the adequacy of that explanation serve?
We don't know what the administration would do. The administration did not want to own this decision. When the Attorney General decided that I'm making this decision because the DACA...
I guess I'm asking about the reliance interests question.
I'm trying to get to that. I
wish you would.
Well, the reliance interests were triggered, to use the words of this court, in the Fox case, the LTV case, and various other cases. Those reliance interests were engendered by the decision by the government that caused people to come forward.
I understand that. The question is, what more would you have the government say about those reliance interests? If it's a failure of adequacy of explaining, what more is left to be said?
What they could have said is that we understand all of these people working for all these people. We understand what people are going through. Provide a reasoned, rational explanation, to use the words of this court just a few months ago in the census case, to explain those things, to explain why a policy is being changed, and make a contemporaneous decision. The Nielsen memorandum came along 9 months later. It was based upon different individual by a different.
Bad Drivers in Milwaukee says 5 kilograms is 11 pounds. Don't you know that we use the metric system in the United States for drugs? It's always the metric system. It's one place the United States has fully converted to the metric system, drugs. So it's 5 kilograms. So when it comes to drugs, we're on board with the rest of the world, man. We use the metric system over here.
For an individual, but it didn't have an administrative record.
Assuming, well, go ahead and finish.
Well, it'll take another sentence or two, but there were a lot of things wrong. The Nielsen memorandum was not an independent decision. She was bound, just as the earlier acting administrator was, because the Attorney General said this is illegal.
But the Nielsen memo then goes on to say, as you heard Mr. Francisco say to my question, that regardless of whether these concerns about the DACA policy render it illegal or legally questionable, there are sound reasons of enforcement policy to rescind the DACA policy, and then goes on to explain the policy rationales to rescind it. So what is your response to Mr. Francisco?
In the first place, they were not independent. They were not contemporaneous. They were not accompanied by an administrative record.
She says they're independent in that sense.
She says they're independent.
At least that's what Mr. Francisco says.
Well, Mr. Francisco said that, and she said that, but they weren't independent because she was...
Theo, I will admit that metric will be better. I will not admit that civil law will be better. I like my common law system very much. I understand common law. I think it makes sense. I understand it. It's great. So yes, I would like to convert to the metric, but I will not give up my common law. And hello, ill propaganda. What's up with you, man? So thank you for joining the stream, and thanks to everyone for joining the stream. If you have not already done so, I would appreciate it if you'd give this stream a like, because it matters for some reason. So that would be nice. And, so yeah. You have a metric lamp, like you have a Chevron ramp. Man, that would be like the only like good that would come out of this. Like, I as a conservative, I'd actually have to think about it. It's like, because like the liberals seem to like not want to rely on the agency discretion. So like maybe I could like, elbow my liberal colleagues and be like, hey, how would you like to say this was an invalid agency action because it was invalid because we want to overrule Chevron? How'd you like to overrule Chevron? I'd actually think about it, because like I hate Chevron with a burning passion. It's like, which do I hate more, Chevron or Wickard? Chevron or Wickard? Man, that's a tough call. I really hate them both. But if we could get rid of one of them, that would be great. So, man, I'm just saying, if the conservatives want to look for an excuse to get their liberal brethren on with repealing Chevron, looks like now would be a good time. So maybe we could do that. Carrying on.
Found by the Attorney General's decision. And the government itself, in its brief that I quoted a moment ago, said DACA was unlawful, thus we had to terminate it. Now, and it's not contemporaneous. And then basically the policy decisions are saying, we understand people may have relied on this, but that's just too bad. That's basically all it was. There were not, and then the litigation risk issue is like a rubber stamp that the agencies can put on anything. Every decision an agency makes could involve.
Do you agree that the executive has the legal authority to rescind DACA?
Yes.
Okay. So the question then comes down to the explanation, and if it's the Nielsen memo paragraph on reliance that it comes down to, so which is the last.
It wasn't. First of all, it was not explained.
Can I just ask the question in this way, which is, assume the Nielsen memo comes in, and assume it comes down to whether the Nielsen memo adequately explained the reliance interests. What was the shortfall in the Nielsen memo in addressing reliance interests? Because she does acknowledge that a lot of people have relied.
Zafal wants to convert to the metric calendar. I don't know what the metric calendar is, but I would be in favor of converting the calendar to 13 months of 28 days, because then every month would start on Sunday, and every month would be exactly 4 weeks long. So 13 times 28 is 364. So that means that we have to have a day, we'll say like New Year's Eve. So New Year's Eve will be the day after December the 28th. And New Year's Eve belongs to no day of the week and belongs to no week of the year. It's a freebie, so that we can have the calendar like always the same every year. And we'll do the same thing for Leap Day. It doesn't belong to any day of the week. It doesn't belong to any week of the year. It's just Leap Day. So, that's how 13 by 28. If we're going to reset the calendar, that's what I would do. So let's carry on.
She does it, and she briefly.
Yeah, she says just too bad. People relied, so too bad. Too bad about that. Camp versus Pitts specifically says when an explanation for an agency.
Oh, Evil Coleslaw says, about some of the crazy stuff they had to do in switching the calendars. Oh, yeah, I know about some of the stuff. I know about the 10 days they skipped in like 14 whatever when they switched from the Julian calendar to the whatever calendar. It's like, yeah, I know when they switch calendars, and like so yeah, there've been some really interesting things when they've switched calendars. I'm thinking it's going to be really hard. The whole entire world is pretty much on the same calendar. It's going to be kind of hard to get the entire world behind the 13 times 28 plan. So I think for better or worse, we're kind of stuck with the calendar we have. I mean, it works, so why mess with it, I guess.
Decision is given. However curt, they must stand or fall on that explanation.
Do you think you could explain the reliance or the justifications for the policy in a way that would overcome the reliance interests?
They would, yes. I believe that that's possible. They could have.
Theo says, I'm only here for the second time. I don't know how you define yourself conservative compared to progressive. Well, I will give you a couple ways I consider myself to be conservative. First of all, I don't consider myself statist. So there's a distinction there, So I'm skeptical of government power, which I think is in line with conservative principles, although you can also obviously be conservative and be more state friendly. So this would be, for example, a split between Kavanaugh, who you would think is conservative, who's more state-friendly, and Gorsuch, who is conservative but is more libertarian in nature. So I tend to be more state skeptical, so I'm more in line with Gorsuch. The other thing that makes me very conservative in disposition is that I look to original meaning, and I look to what things meant when they were originally passed. So, like, if you ask me to interpret the First Amendment, for example, and you ask me to interpret freedom of speech, my first step is like, what did it mean in 1790? So I don't believe in like a living constitution. I don't believe in an evolving constitution. I believe things meant when Congress passed them, whatever that might be. So Congress passes a law today. It means what it means when Congress passes it today. And it's still true in 1790. I also tend to believe in, I believe in individual rights and individual autonomy. I believe in negative liberty as opposed to positive liberty. I believe that the role of the government is basically what some kinds call the night watchman philosophy. The role of the government is to stay out of my life and keep everyone else out of my life. So it's all negative liberty. The government's role is to make sure that I am left alone and not to give me anything. So I'm very skeptical of illegal immigration. That makes me conservative. Deport them all would be a viable plan for me. Again, I'm not necessarily opposed to reforming the law, but as long as the law is the way it is, I want to enforce that. I'm skeptical of spending more money than we have. I would prefer a more balanced budget. I'm skeptical of government expenditure in general. So those are ways that makes me conservative, as opposed to progressive. Judicially, especially, what makes me conservative is I'm more originalist. So I look to original understanding, original meaning, as opposed to contemporary meaning or contemporary understanding. And I think that things mean what they meant, and that is what it is. So those are ways that I define conservative for this exercise.
Analysis of costs and benefits, explaining why an OLC decision is being thrown out the window, why a policy is being changed that the administration is being formed. That's exactly what you have said.
Mr. Olson, can I go back to something Justice Gorsuch asked, which is, what's the benefit of delaying this further? It has been, at least looking at the deferred action decisions, the dozens that have gone on through the decades, Congress has responded, sometimes changing the policy, sometimes limiting it, sometimes expanding it. It has responded. But the dynamic is very different, isn't it, when an executive says, I don't have the power, and when it says, even if I had the power, I choose not to do this. Aren't the dynamics of what happens between Congress and the President dramatically different in those circumstances?
Exactly. This is what is called virtual reality, when it says, I don't have the power to do it, but if I did, in the sky, I might have done it for this reason. The short answer to your question, Justice Sotomayor, is a very good one. Someone say, I might have done it if I'd had the power to do it, but I have no discretion, I have no power to do it. We don't know what the administration would do if it had to make this decision and take ownership and accountability of this decision.
That's your point about, given the Attorney General decision and the law that says they have to change it. That's a very different circumstance than saying.
Also, I am very pro-gun, so I interpret the Second Amendment extremely favorably to gun rights. So that also makes me conservative. Carrying on.
Even if I don't have to, I won't.
That's exactly right. The administration would then have to explain, we want to take responsibility for throwing these people out of work, removing people that came here when they were maybe 2 years old, who have not committed a crime, and who have volunteered for this program, have conducted themselves properly, and so forth.
I understand that litany. But do you seriously want to argue that if this case were to go back and the agency were to say again exactly what General Francisco interprets the Nielsen memo as saying, giving all of these reasons and saying that each one is an independently sufficient basis for the action, would that be unlawful? And let's say they go into great length in explaining every factor, every basis.
Certainly.
If they explained and provided a rational explanation instead of just pushing a button or putting a rubber stamp on it, that's what judicial review is all about. That means the agency would have taken responsibility for making the consequences of those decisions, explaining why it thought about it and why it decided what it do. That's what your decisions require by judicial review.
Thank you, counsel.
So excuse me. So we're going to have 3 arguments today, and the government, they actually ordered extended time too. So Theodore Olson, who I'm pretty sure was a former Solicitor General and is generally considered like one of the best advocates for the Supreme Court, he was hired to advocate for the private individuals. And so Mr. Mongan is arguing on behalf of the state. So we have the Solicitor General arguing for, or on behalf of the University of California, to be more precise. So we had Francisco arguing on behalf of the United States government. We had Olson arguing on behalf of the Dreamers, and then we have Mongan, who's arguing on behalf of the University of California. So let's hear, and they ordered an extra argument, so we get an hour 22 today as opposed to the normal hour. So hey, bonus time.
Mr. Mongan.
Mr. Chief Justice, and may it please the Court. It was up to petitioners to decide how to frame their decision to terminate DACA. They could have taken responsibility for a discretionary decision rescinding a policy that affects hundreds of thousands of lives. Instead, they chose to end the policy based on the ground that DACA was unlawful. They told the public that the law deprived them of any discretion to continue it. And when Judge Bates invited them to make a new decision, they stood by the old one. That's their prerogative, but it has the consequence that they have to defend that decision based on the legal rationale they originally offered, and the decision is reviewable and cannot be sustained on that basis. Now, the problem with the rationale is, yes, they don't take serious account of the dramatic costs to DACA recipients and the economy and their employers and families of terminating this policy, and also that it is founded on the incorrect legal premise that DACA is unlawful. This Court can review the lack of and affirm based on the lack of an adequate explanation for that ground, or the fact that it is an incorrect conclusion and it is legal error. Now, if I can turn to the question of reviewability, the APA says that it commits agency actions that are committed to agency discretion by law are unreviewable. And the central point here is that when an agency founds a decision on a public announcement that it lacks any discretion to continue a policy, that can't fairly be described as committed to agency discretion in any meaningful sense. This is the concept that the Court reserved in footnote 4 of Cheney, because that is not a discretionary choice that the law has committed to agency discretion. I think that it is critical for us to consider on the merits what my friend's position is with respect to DACA and deferred action. My friend appears to agree that they can grant deferred action to compelling individuals, that they can grant work authorization to deferred action recipients, and they seem to agree that this is a very worthy class of individuals. So their position boils down to the assertion that the INA prohibits them from adopting a transparent framework that guides the exercise of individualized discretion with respect to this very compelling population of individuals. And that's not consistent with the broad authority that Congress has granted the Secretary under the INA and under 6 U.S.C. 202, and it's not consistent with historical practice, where the agency over the decades has frequently adopted class-based discretionary relief policies that allow it to channel the exercise of recognized forms of discretion with respect to particular individuals in a defined class.
Well, that history.
First of all, just generally, I am enjoying the questions. I like, I like talking with you guys. I like conversing with you guys. I like thinking. I like explaining myself and trying to express positions. So first of all, I just want to generally thank you for questions, and I find them enlightening, and I hope my answers are, equally enlightening back. To answer some questions that were raised, Theo asks, are you pro-humanitarian law with respect to torture or genocide? Well, here's what I think. First of all, I am skeptical of people who claim torture and genocide because, they are claiming. I'm very concerned that they're claiming it not because it's true, but because they think it's a free pass, and to get into our country or, benefit. Because it's like, people are here for amnesty. It's like, well, just because you say I don't believe in magic words, right? So I'm skeptical of claims because I don't want this to become a magic words. Like if you say the right words, you get a pass. So I'm skeptical of those claims. That being said, in the case of a true case, where it's really true, like we can, move outside into the ether and establish it is to be true, I think, the United States has a role to play in providing refuge to people who are so affected. I think our role, however, should be no greater than any other country that would be considered like a free country. So, I think there should be perhaps some kind of system that, maybe like the UN or something could get along and countries could coalesce and if your case can be sufficiently vetted, and sufficiently documented, then we will pick a country to send you to. You don't get your choice. Because you're freeing genocide and torture, right? So any free country should be equally good from your viewpoint, right? They're all equally fine. So maybe it can be based on population or based on resources or something. But I don't want this to be the United States becomes the default free country for everyone in South America. I don't want this to become United States is the sucker because they can get to the United States and well, you could keep going to Canada, but we're going to stop here. It's so that's how I think about it. It's yes, in the case of genuine torture, genuine refugees, I'm happy to give them some sort of protected status, but I'm only happy to give them such status, in terms of not being a complete sucker with the rest of the world. So that's kind of how I feel about that.
Is not close to the number of people covered by DACA.
Well, Your Honor, there's a history of class-based deferred action policies, and they are narrower, to be sure. But there are other class-based policies that have applied to hundreds of thousands of individuals. The family fairness policy, when announced, would have applied to up to 40%
well,
of
50,000 people, right? That's the number that availed themselves of that policy?
That's right, because it was short-lived. But at the time it was announced, it was not clear that Congress was going to act, and the executive told Congress that this would apply to up to 40% of the undocumented population at the time. When Congress did act in that statute, they signaled their approval of the executive policy. The statute didn't have an effective date for another year, and Congress said that this is not intended to express disapproval of the existing executive policy. And that's one example, but there are more examples of
that percentage was 1.5 million people. Very comparable to this decision.
Yes, and at a time when the total undocumented population was much smaller than it is today. Now, it is critical for the executive in an area where it has broad discretionary authority to be able to set policies that channel the exercise of that authority. And this is a transparent framework that has the benefit of allowing for some measure of consistency and an even-handed approach in the exercise of deferred action.
General, suppose that this administration had not relied on legal grounds to rescind the policy, which is very different from what they did, but let's just suppose otherwise, that they had immediately and only relied on policy considerations. Are you saying even then it would the rescission would be reviewable, and why would that be?
So if it were a pure policy rationale, It would fall outside of Cheney. It would be presumptively reviewable, as most agency actions are. I think it would be challenged, and the challengers would likely argue that there's sufficient general standards in this area to allow for a minimal level of rationality.
Why would it fall outside of Cheney, do you think?
I think that Cheney was very specific about the type of agency action that it addressed. It was a concrete decision by the agency not to enforce a statute with respect to particular actors. Now, that is different from a broad policy that guides the exercise of deferred action decisions prospectively. And Cheney was founded on a recognized tradition of non-review. It pointed to cases going back to the 19th century.
Well, when you say particular actors, did it not apply?
You know, going back to like the asylum seekers, you know, there was like a bunch of people who were leaving like South American countries. And I was always like, you know, you could go to Belize. Belize is pretty nice, you know, as far as countries go. It's like right next door. You could just go there, but you came all the way to the United States instead of going to Belize, even though it's a bordering country. So it's like, you know, is it really that you were fleeing terror, or is it that you wanted to come specifically to the United States? I'm like a little skeptical on that one, just saying.
To anybody who was facing execution using by lethal injection?
Yes, Altira Moongara says, does the time the justices are asking questions affect the amount of time? Yes, it does. Yes. Can the justices use up all the times? Yes, they can. Yes, they eat into your time. You're given normally a half hour per side, and as much time as the justices take, that they take. So hypothetically, if they spend all 30 minutes asking questions, I guess sucks to be you. So yes, they get to eat as much time as you want. So, you know, one of the things you have to prepare for as an advocate going to the Supreme Court is being able to adjust your argument on the fly as, you know, time appears to be running away or not, depending on how things are going. So yes. And you do get the first 2 minutes for free. New rule this year. So you get the first 2 minutes for free. And usually like the last, because the light comes on, there's a green light, yellow light, red light. So the yellow light comes on for 1 minute left. And usually, but not always, usually they give you that last minute for free, but sometimes not. So they give you 2 minutes to start for free, sometimes that 1 minute for free, and otherwise, well, just hope for the best.
Well, as General Francisco has noted, there were broad policy considerations underlying the decision, but as it was described by the court, it was a decision not to enforce with respect to particular prison administrators and drug companies. And I think a different point here is that...
Well, hasn't that been FDA policy for all of the years since Cheney?
Sure, Your Honor, but that's
a big class of people.
But that's a flat determination not to enforce, as opposed to a policy guiding future decisions about whether to grant deferred action, which itself is not a flat or final.
How does that make a distinction? Like, it's a flat determination not to enforce that affects a lot of people. But presumably, if they change the decision, it would be like the same rationale. So I'm not seeing the distinction between the two. It's like, okay, carrying on.
Non-enforcement decision. They have argued that deferred action is revocable at any time and could be, and is not a defense to removal. So we're dealing with a different type of policy here than the one that the agency dealt with in Cheney.
I mean, look, I've always thought, well, it means the individualized kind of decision, but quite rightly, the Solicitor General reads me the language, which is programmatic. But the United States has hundreds, thousands of agencies which do enforce all kinds of things, which make programmatic rules all the time. And so it can't mean that Heckler is interpreting this committed to agency discretion to make serious inroads in the principle of judicial review. But everybody's struggling, including me.
Oh my God.
What's the line? And what's the line generally? It can't be so broad of all programs. It can't be so narrow as an individualized decision.
Oh my God, it's an actual question Oh my holy lord. It's an actual question. Wow. Wow. I mean, wow. What is the line? Like, there's lots of agencies who do lots of things. It can't be we have to do all these things. So how do we decide? It's an actual question, and it didn't go on for 5 minutes. Wow. Amazed. Carry on.
Just what is it?
Well, I think we can look to the language of the Cheney decision. It describes a decision not to take enforcement action. So perhaps if there is a broad policy that is a flat, categorical decision that we will not take enforcement action, that would be one thing.
And imagine an SEC rule, or imagine a HHS rule. And what it says is, we are not going to take action to give a certain category of people their benefits. Not reviewable? I mean, nobody would think that. So we're struggling still. And I'm saying honestly, I am struggling to get the right rule.
I understand, and there may be ambiguities at the margins here, but I do want to focus it on this case, because here, Acting Secretary...
That is a very sharp answer from this advocate. So I really, really like this answer. Like, he's ducking the question, but he's doing it in a very intelligent way. So he's like, because they're asking for a line drawing, and he doesn't have an answer. So he's saying, like, there are ambiguities, but I want to focus on this case. So it gets from the broad, it's forest versus the trees, basically. So Breyer was just asking a forest question, which is, nice. It was an actual question. And Morgan's saying, well, let's talk about the tree. So that's a good answer to a very tough question, because he doesn't have an answer for the trees. He doesn't have one. So all I can do is say, well, focus on the case before us and call it a day. So good answer. Actual question. Good job from this advocate. I like it.
Duke identified one ground for terminating this policy. She said that she pointed to the Attorney General's letter, which concluded that the policy was unconstitutional and beyond statutory authority. And whether or not this might conceivably fall under Cheney, if it does, it still is subject to...
So you're saying at the minimum, an action to enforce is different from an action not to enforce. Here we have one to enforce, and you're saying as well that the ground being purely legal, it is not a discretionary ground. He said it was illegal, and therefore it is not within discretion. Okay, I got those?
Wait a second. It could be just me, but I don't think that's a fair characterization of what he said. He gave an answer, and then Justice Breyer summarized it in a way that was not really what he said. It's it's the answer Justice Breyer wanted him to give, which I guess is one way to sneak it through the back door, but it's not really the answer he gave. He gave the answer he wished he had gave, and he's is this the right answer? Of course, the advocate picking up on this, because the advocate is not an idiot. The justice just said, well, what I think you basically meant to say was this. Those answers, by the way, are very favorable. Is that what you meant to say? Of course, that's exactly what I said, Your Honor. So the advocate is doing exactly what he did. I just want to point out that Breyer is pulling a fast one, and yeah, noted. So carrying on.
Too right?
That's right, Your Honor.
Anything else?
I think those are what we have focused on in this case, and that...
Well, counsel, I'm sorry to interrupt there, but I actually had understood your answer on the second one to be different when you were...
Oh, shoot. I think I killed it. Sorry, Juan, about the Nightbot thing. I'm going to fix that for the too many symbols. I, installed Nightbot and didn't quite understand what it apparently was doing, so that's my bad. I wanted to help, and it's just making things worse. Let's see. Where did I leave off? Sorry. Let's see. Okay, we went past that, past that. Past that. I think we're here.
That's right, Your Honor.
Anything else?
I think those are what we have focused on in this case, and that...
Well, counsel, I'm sorry to interrupt there, but I actually had understood your answer on the second one to be different when you were posed that question by Justice Kagan. And I thought you had indicated that whether it was based on policy grounds.
Could you tell me more about Google, YouTube, Gmail purge? Is that the new rules for YouTube, you mean, with the like CAPA that you're referring to? Because if it affects my Gmail, I'd like to know more, but let's carry on.
Or on a legal assessment wouldn't alter the reviewability analysis in your view. So I guess I'm just curious, which is it?
So to be more precise.
Theo says, I somehow can't really defend why I should have more rights to a certain citizenship than other people from around the world. Well, it is an accident of birth, but, you know, the Constitution does say we, the people of the United States, which supposes there is such a place as the United States and supposes that there is such a thing as the people of such. So, like, you know, the country is created for our benefit, and, you know, whoever's part of that club gets to be part of the club and whoever's not doesn't. So, you know. Supreme Court should make a ruling on Nightbot. Yeah, well, yeah. I put it in. I don't know why. I thought it might be a good idea. It's a little aggressive on the smile. Sorry, Juan. Apologies to Juan here.
If we're operating in a world where we assume that Cheney applies, our point is, regardless, this is reviewable because this is within a subcategory where the agency has disclaimed any discretionary choice. It has said we have no authority over the matter, and that can't.
That wasn't my. I'm sorry, that wasn't my question. So if assuming we're living in a world in which the agency had alternative grounds, and one of which was policy grounds, I had thought you told Justice Kagan that this would be reviewable. And now I thought I understood you to say something slightly different to Justice Breyer, and perhaps I'm missing something.
Well, let me try and clarify. We believe that a broad policy is not the type of action that's referred to by Cheney, consistent with some of the D.C. Circuit authority that's been cited in the briefs.
Well, I think Justice Breyer, that just takes us back to the beginning of the discussion with Justice Breyer, which is that can't be so necessarily, because every prosecutorial discretion affects a lot of people. You had that discussion with Justice Alito as well. So I guess I'll let you go, but I'm still struggling with this line that you're asking us to draw.
Well, it may be a difficult line to draw in the general case, but in this case, with respect, it is an easy line to draw because we know that this decision was founded on a binding legal determination by the Attorney General that they could not continue this policy. And
what if it were less, as you view it in categorical terms? What if the Attorney General said, I've looked at this, it's a close case, but on balance, I don't think we have the authority? Or if he said, I'm pretty sure we don't have the authority, but a court might come out differently. Does your analysis change, or is it only when he says, this is, as far as I'm concerned, this is definite, it's illegal?
No, Your Honor, we would argue that it's a type of action that's presumptively reviewable, and if the agency decides to base a decision on some discretionary choice but with an explanation or rationale that's founded on litigation risk or legal doubt, that would be a rationale that courts would be
equipped to review. Is it enough for him to say, look, I've got a decision from the Fifth Circuit that tells me this is illegal, it's been affirmed by the Supreme Court by an equally divided vote, that's enough for me to say we're not going to do it?
It's not enough to sustain the decision, Your Honor. I think that under these circumstances, given the nature of this program and the interests at stake, we don't think that any genuine statement of legal doubt or litigation risk would be adequate. But that's not what we have here.
Even if you went through a legitimate balancing exercise, in other words, you talked about the law and what you were worried about, and then you talked about the reliance interests, and then you said, here's what we're weighing, and here's our judgment. Do you think that would be sufficient?
I think as a general matter, an agency could base a discretionary decision on a reasoned analysis like that. I suspect that if we saw that decision, we would challenge it under the particular circumstances here, but the Court might agree that if there were some substantial and detailed consideration of the actual costs of this and the reasoned legal analysis, then maybe that would be in a court's eyes sufficient. But that's absolutely not what we have
So if you prevail and the case goes back, is it enough to say, look, we've read the amicus briefs that Justice Breyer pointed out about the reliance interests. We've read, the Fifth Circuit's opinion in the Texas litigation. Presumably they would cite that as well. Would that be enough?
I think that it would have to begin with the deficiencies that Judge Bates identified, which is that the agency has not actually identified with any particularity the legal grounds that it's concerned with. It does cite the DACA case.
Yeah, I mean, what do you need more than that? You've got a Court of Appeals decision affirmed by an equally divided Supreme Court. Can't he just say that's the basis on which I'm making this decision?
Your Honor, no, and I think Judge Bates is exactly right on this. The reasoned explanation requirement is meant to facilitate judicial review and inform the public. And yes, they point to the DACA case, but there's 4 or 5 theories of illegality floating around there, ranging from the notice and comment to the take care clause claim, and we don't know which ground the agency based its decision on. So that is a lack of a reasoned explanation, in addition to the fact—
What would an adequate explanation look like? I mean, what do you think they would have to do to be in the clear on this?
Well, I think that they would at least have to identify the particular grounds that they're relying on to facilitate further judicial review of their underlying legal conclusion, and explain why they believe it applies to the DACA policy when they pointed to a case about a different policy, and then have some serious and more serious than what we see in the Nielsen memo accounting of the very substantial—
But suppose they say, yeah, we'll do that. We'll do that. And now, the authorities are legion on that we should decide on the basis of that Duke memo. That was the decision. Rested on that, and you've heard that. Okay. There's another case where Justice Fortas wrote, you shouldn't play ping-pong with the agency. Okay? So they're saying that's what a lot of their argument was. What's the point? What's the point? I mean, you'll send it back and they'll say, okay, right, DAPA was different. In DAPA, the court said that the DAPA program makes 4.2 million people citizens with a runaround of the normal way to become citizens when you have a child who's a citizen. And here that has nothing to do with this case. They're not, no runaround. Okay, you point that out, they point, well, we're going to come out the same way. It's close enough. So, what's the argument against playing, as there is a sentence against you, playing ping-pong with the agency?
Again, with an actual lucid question. Who are you and what have you done with Stephen Breyer, man? Jeez.
I think that there is a very substantial meaning to a remand in this case, Your Honor. We don't truly know what the agency would do if confronted with a discretionary choice. If they knew that DACA were lawful, there's a new secretary, and the administration has expressed broad sympathy for this population, and they very well might continue the policy or stop short of wholesale termination. And if we are remanding in light of the lack of a reasoned explanation, my friend has said—
It was remanded by Judge Bates or given time, and Secretary Nielsen did what you just said and said even if DACA was legal, you heard Mr. Francisco on that, I would exercise my discretion to rescind, and then explained her consideration of the reliance interest. So there's already been in effect a remand.
There is a boilerplate assertion in that memo of independence. I will grant you that. I think if we look at the circumstances—
Well, can I just stop you on boilerplate?
Yeah.
And this is a serious decision. We all agree with that. And it was for the secretary, presumably. And to say in writing, even if it's lawful, I nonetheless am going to exercise my discretion. I assume that was a very considered decision. Now, we can agree with it or disagree with the merits of it, but it seems—
Yes, and I think it's important to look to the penultimate paragraph in that memorandum where she conducts her collective weighing, and she considers those policy rationales along with the legal rationales, and say that together, they outweigh the purported costs of terminating DACA. I also think it's critical to understand the context of this.
So your point, just so I understand, I think this is your point, is that the legal considerations, while she said that, end up being intertwined in the subsequent paragraphs with the policy considerations.
That's absolutely right. And this was, after all, in a context of a memo that they submitted to the district court in ongoing litigation intended to defend and explain the prior decision. And I do want to note here that to the extent that my friend has suggested this is a new decision or a new action and has been presented as such, that's not consistent with what they told the district court. The district court said quite plainly, please notify me if there's a new decision. They submitted this memo and said this is a motion to revise your order with respect to the original Duke decision. We want you to sustain the Duke decision. And the district court took them at their word and treated it accordingly. So I don't think that they can come to this court and suggest that it is a fresh decision and every rationale is before the court under Camp.
In that penultimate paragraph, what is the shortfall in the discussion of reliance interests in your view?
Well, I'm not sure that there is much of a discussion. She expresses some sympathy and then ultimately says that it is up to Congress to consider and weigh the reliance interests and the costs. It's not a detailed discussion of the dramatic harm to hundreds of thousands of young people, to their families, to their employers, to the states, to the economy that would arise from this decision.
But she does say that in a sentence. If we remanded and it were detailed more fully, would it still fall short?
I think the great value of a remand is that to date, they have not made a decision that actually takes ownership of a discretionary choice to end this policy. And if they had a remand, if that is their intent, they could issue a new decision that actually does that so the public could hold them accountable for the choice they've made.
Thank you, counsel. 5 minutes, General Francisco.
Thank you, Mr. Chief Justice. I think I want to focus on 3 basic points. First, Justice Kavanaugh, I want to make sure you have all of the relevant portions in the Nielsen Memorandum that I think make this all quite clear. Page 122A, and I'm at the Regents Petitioner's Appendix. In considering how DHS's discretion to establish enforcement policies and priorities should be exercised, the DACA policy properly was and should be rescinded for several separate and independently sufficient reasons. She then gives the first reason, the legality question. Then if you go to page 123A, second, regardless of whether the DACA policy is ultimately illegal, it was appropriately rescinded by DHS because there are, at a minimum, serious doubts about its legality. Further down the page, third, regardless of whether these concerns about the DACA policy render it illegal or legally questionable, there are sound reasons of enforcement policy to rescind the DACA policy. And then she sets out the enforcement policy. If you move to page 125A, where she's discussing reliance, quote, I do not believe that the asserted reliance interests outweigh the questionable legality of the DACA policy and the other reasons for ending the policy discussed above. And finally, when you get to the conclusion on page 126A, for these reasons, in setting DHS enforcement policies and priorities, I concur with and decline to disturb Acting Secretary Duke's decisions to rescind the DACA policy. So frankly, I don't understand.
From all of that, don't know how she would respond if there were a clear recognition that there was nothing illegal about DACA. Our whole memo is infected by the idea that this is, one, illegal.
No, I mean, not the way that he just described it. It's not. She set out like 3 independent rationales. First, it's illegal. Second, there are the serious questions about legality. And third of all, it's good as a matter of policy. So, like, that's perfectly valid legal reasoning. It's like it's arguing in the alternative. It's clearly illegal. If not, we had serious doubts about it. If not, we should do it anyway. Seems well in line with the FDA precedent. Seems well in line with normal administrative procedure. Seems like they consider their reliance interests. It's a very long memo. Goes through everything in detail. So, it seems like enough to me. So, okay, carrying on.
At least substantial doubt about its illegality. If we take that out, then the independent ground that you're asserting, then she would be saying, we stand up and say, this is the policy of our administration. We don't like DACA, and we're taking responsibility for that. Instead of trying to put the blame on the law.
Respectfully, Your Honor, I very much disagree. She sets forth explicitly on page 121A several separate and independently sufficient reasons. We own this. We both own the policy rationale set forth in Secretary Nielsen's memorandum. Also, because we think this is not subject to judicial review at all, we own the legal judgment set forth in Secretary Nielsen's memoranda. So simply stated, the fact that we've got alternative and legal policy grounds for making this decision make two things clear. First, it is foursquare within Cheney under the revealability issue, because Cheney likewise was rested on alternative legal grounds. The FDA believed it lacked jurisdiction and policy grounds. And secondly, it shows how this was plainly an eminently reasonable rescission, even if you disagree with us on the legal issue, because we've set forth separate and independent policy issues for the decision. So that was basically my first point.
But even what you just read, General, in that key paragraph where the Secretary weighs the reliance interests against the reasons in her memo, everything's wrapped up. And we really don't know how she would have conducted that balance, how she would have weighed those two, if the legal had been taken away from it.
I simply disagree with that. When she specifically says that she's setting forth separate and independent grounds justifying the rescission, I don't think that there's any fair way to read that, but by saying that she would have rescinded it based on any of the independent grounds, which brings me...
the independent grounds. Number one, we should not adopt a policy of non-enforcement of those laws for broad classes and categories. Okay? In Congress, she thinks agrees with us. Well, I don't know. Maybe they do, maybe they don't. But aside from that, that's a conclusion. Look at the second one. We should do it on a truly individualized case-by-case basis. That's a conclusion. That isn't a reason. And the third one is a reason. The third one, it is important to project a message that leaves no doubt regarding the clear, etc., enforcement of immigration against all classes. That's an independent reason.
May I finish? I'm going to try to squeeze in 2 points in a single sentence. The first point is that I very much disagree. All of those articulate the basic same policy rationale, that this is a law enforcement agency. They are against general policies that actively facilitate violations of the law. And the last point I will make is, well, we don't think you need to address the legality question if you agree with us on any of our other arguments. If you disagree with us on any of our other arguments, you absolutely must address the ultimate legality question, because we simply cannot be forced to maintain a policy that this court concludes that is illegal. So if you decide to get there, then we do think that DACA is illegal and was justifiably rescinded on that basis as well. Thank you, Your Honor.
Thank you, counsel. The case is submitted.
Well, I'm roughly where I started this one, and, I told you what I thought before, and I'm still the same place. So, I try to admit my biases where they are. So my view is the left-handed side of the court is just very grumpy on the policy, and it's trying to squeeze this into a legal rationale, and it's basically trying to concoct an excuse. Well, they just didn't do enough, and if they only dotted the I's and crossed the T's, we would have upheld it. But they just didn't do enough, because they didn't address the 30 briefs and the 50 briefs and the 100 briefs and the 500 briefs and the 3,000 briefs and each one of the people individually and all their reliance concerns and all these things and blah, blah, blah. So it's like, yeah, I just find it not credible. I find it to be, an excuse. And I think when they're laying out the lives are going to destroy in that frame, it's like, to me, that was pretty clear. I think the case law precedent is pretty clear too. It's like this precedent they referred to is pretty solid. It's like, yeah, you can do this. It's like, if you're not sure, you can come up with multiple reasons and each are more sufficient. You considered it. You did enough. It's like, why bother? So my projection here is 5-4 decision, typical 5-4 split. My decision is, I think they're going to vacate the decision below. And they're going to say that this is not within the court's discretion. It's non-judiciable. So I think it's going to be a 5-4 decision to vacate both the Court of Appeals decision and the district court decision, because they didn't have jurisdiction to hear it in the first place. And they're going to cite the FDA case as principal authority and say they did enough. And so the administration will begin its wind down, and that's kind of the end of that. So, that's sort of where I think this is going. So, yeah. Traditional 5-4, but yeah, Kagan, Ginsburg, Sotomayor, and Breyer. Don't know who's going to write it for the minority. No, really, doesn't matter. Don't know who's going to write it for the majority. Probably not the Chief Justice, because it's a little bit politically sensitive. So he probably doesn't want to do it. So I would imagine, take your pick of the other 4 justices in terms of who will write this. Maybe Thomas, but whatever, it doesn't really matter. So, and for me, it's like the DACA itself put in a 2-year period of restriction. So it's like, how much reliance interest can you possibly have? I mean, it was meant to expire. So like, whatever. So that's kind of how I feel about it. So, I'm with the government on this issue. I think that, I think Obama could do it lawfully because it was essentially prosecutorial discretion. I think Trump can undo it because it's essentially prosecutorial discretion. I'm not sure anything under the ADA is required. To the extent anything was required under the ADA, then I think that they met that burden under the relevant case law. And I think it's non-judiciable, given the fact that this is a matter that the federal government, the Congress, has delegated to immigration. Immigration is doing rulemaking and interpreting its own rules. And so, cite Chevron if I have to, even though I hate the case. And, that's basically the rationale. So that's what I think it's going to be. I think it's going to be a traditional 5-4 split. And the decision is going to be to vacate the decision below. So either reverse or vacate would be my bet. So that's what I think. So there was some, let's see if there's any questions or comments. Better send these kids raised in the U.S. to a country their parents never came from, never been. Yeah, I mean, kind of, sort of. I mean, it's like, they don't have any particular right to be here. So, they can go to a country they have a right to be, that they have citizenship of. And, I do not think the United States should be the unilateral refugee place for the entire world. I just don't think that's true. There's a lot of people in a lot of places in the world that are in a lot of distress. And I don't think the people that somehow managed to get here are necessarily special opposed to everyone else. Just because they managed to get here. It's like, we know them because they're 5 feet away from us instead of 5,000 feet away from us. They're 5,000 miles away from us. But it's like, fundamentally, this kid that's in the United States is no different than the kid in Malaysia or wherever that was left behind, right? So it's like, why is this kid here more special than the kid there? Because he happens to be here instead of there? It's like, and I don't think we should be like the refugee place of the entire world. I just don't think that. I think that to the extent we should be offering humanitarian aid, I think other countries in the world should be offering equally, and it should be based on capacity and other things. And I just don't think, the fact that they are used to this is not enough for me. It just doesn't quite fly. That's my bias. I'm a stickler for legal immigration. Whatever that is, the Trump administration apparently wants to lessen legal administration too. Or legal immigration. Personally, that's a debatable policy too. If you want to limit legal immigration, as far as I'm concerned, the United States can have any policy on immigration it likes. It's just a fundamental right of a sovereign to decide who is and who is not allowed within its borders. The United States could say there's no legal immigration, no one can even come to visit, no visas, no tourists, no nothing. That would be legal. Now, it'd be pretty stupid as a matter of policy, but I think it's within the power of the sovereign to decide that. So, if we want to have a debate on legal immigration somewhere, within the threshold, then that's fine. But whatever the policy is, I think the policy should be, and it should be uniform. And I think, I just fundamentally don't think it's fundamentally fair in a lot of ways. Just because a parent brought their young kid here, there's a parent with a young kid who wasn't able to come here, who's, begging for a chance of admission. And I just think that they should be treated the same. Just because they were able to get here, I don't think they should be treated specially. There are people out there who are trying to follow the legal process, and, it's burdensome and time consuming. And I don't think the people who come here illegally, should be able to skip ahead of all the people who are trying to come here legally. I imagine like two sets of parents from, say, El Salvador, to pick a random country because it's a South American country. But let's say there's two sets of parents from El Salvador, and one set of parents brought their child here, and one set of parent, is trying to immigrate lawfully. I don't think the set of parents who managed to come here with their child should get preferential treatment over the parents with the child who's trying to come here lawfully. Just because they managed to get here. I just don't think that's fair to people who are trying to play within the bounds of the rules. Again, if you want to change the bounds of the rules, I think we can have a lawful debate on that. But I just think it's not fair to people who are trying to play by the rules. And, so I think that's kind of what I think about that. Read what's on the Statue of Liberty. I'd like to take note that we didn't build the Statue of Liberty. It was a gift from France. So I'm not sure how much liability we should have for what's on the Statue of Liberty, since we didn't create it. We simply accepted their gift and put it on Ellis Island. So, just noting that we didn't write those words, France did. So if you want to say, give us your tired or poor, send them to France. They're the ones who wrote it. So, and also what's on the Statue of Liberty is not law. So it is not like binding for all times either. So it's like, it's just, it's an interesting poem and has some value, but, I don't think it exactly sets forth what immigration policy is or should be. So I think the words themselves weren't from the French. Well, I don't know. I honestly don't know. I assume they were. Maybe I'm wrong. But it's not on the pedestal. I thought it was on the tablet. Or maybe I'm wrong. I don't know. I don't know where the words come from. So maybe you're right. Maybe it's not. So, either way, I don't think it's, binding legal policy. So, yeah. So we wrote the words. I stand corrected. We wrote the words, but still I don't think it, permanently binds us. So, give us your tired, poor, people yearning to be free. It's like, what does that mean? And it's like, what should that mean? Does it mean all the tired, all the poor, all the people yearning to be free everywhere? I mean, it seems like it can't possibly be that extensive, right? It's like, we should be the universal refugee for the entire world. It's like, no, that doesn't seem like that's a good policy. I just don't think that seems right. So it's like, so it's like, that's kind of how I think. We need Starship Trooper citizenship. That's a little bit much for me. I don't know that we should go down that road, but especially in light of the 14th Amendment, but, that's fine. Capitalism is the problem. Not all people want to live in the U.S. Well, yeah, that's fine. Working in an immigration law firm, I see the fundamental unfairness in how the laws are administered. It's like playing craps. Yeah, I understand that, but I don't think the cure to fixing that unfairness, fundamental unfairness, is by putting in structure of more unfairness. Like, if you manage to get here, you get a pass. That just seems even more unfair. So, like, I don't think the cure is to fix the fundamental unfairness is by giving anyone a pass who managed to get here. It just seems like that's not fair to everyone who was left behind, right? So it's like, let's see, what else? Going back is not possible. It's like, well, whether it's possible or not doesn't make us, again, the refugees of the world. And how do you know it's not possible? It might be possible. So, like, what makes it possible or not? It's like they're we cannot be the refugees of the world. It's like, it just doesn't, it can't be, in my view, that we should be, open to anyone who can get here, unlimited open border immigration. That just doesn't make sense. We have a right as a country to, like, vet who's coming in and see if they're compatible with our culture and our values and are net positive to us as a country and the rest of it. So it's like, I'm a bit of an immigration hardliner, I guess. I'm not, not that sympathetic to people who are here illegally. So that's one way I'm conservative. So Dogbert says he's a Ms. refugee based on religion. Again, it's like, I think we should participate in valid refugees. I think we should participate in a way that like somehow equitably distributes it among free countries of the world, So it's like, I think that's what I think, So, if you're truly a religious refugee, then presumably any country where you'd be religiously free would be equally good if you're truly being religiously oppressed, right? So like any country that's religiously free should be equally good. So, I'm glad you're here, but it's like, there are a lot of people who are being oppressed in a lot of places. It's like we can't be the universal like piggy bank for that problem. That's sort of what I think about it. Yeah. We definitely have less space. Well, it's not a space issue. It is a resource issue. So it's like, whether or not we should be the world police is a whole nother set of problems. Personally, I'm a little bit more constrained on that. I'm a little less willing to be the world police than perhaps a lot of Republicans are. I don't, I think that, it's a complicated issue because like, just because we pull out of places creates power vacuum problems, creates all kinds of problems. So I don't know if it's necessarily as simple as like saying we shouldn't be engaged in a lot of places, but I'm skeptical of U.S. involvement in a lot of places. So I'm a little bit more constrained on that than some of my more conservative brethren on that subject. Skeptical of the U.S. role of being the world's policeman. I'm not sure how we got into that role. So, yeah, service does guarantee citizenship. Yeah, a little bit. As my understanding, if you serve in the military, it gets you citizenship, which I guess is fair enough. I suppose as far as it goes, it shows a lot of dedication in the United States, right, and a lot of willingness to serve. So that's kind of how I feel about that, and I understand if people disagree with that and think we should have different policies. And I think, again, this is part of the grand debate of like what should be lawful and what shouldn't in terms of immigration policies. Like, should we be open to people from everywhere? Should we have unlimited caps, whatever, stuff like that. But I just think like, whatever rules of law, we're supposed to be a country of the rule of law, right? Everyone agrees on this principle. We're supposed to be a country of the rule of law, right? So like whatever rules we collectively decide on, we should enforce as the rule of law. So I just have a fundamental problem with like ignoring our collective policy judgment as reflected in our statutes. It's like, that's my problem. It's like, how can we be a rule of law and look aside as, all this stuff is going in, not in compliance with our own systems. Again, the system itself is a whole nother subject of debate, but it's like whatever the rule of law is, I think should be enforced. So like, I just have a fundamental problem with illegal immigration. I have a fundamental problem with giving illegal immigrants a pass. I have a fundamental problem with anyone who happens to get here, get some sort of special treatment. I have a fundamental problem with anyone who brought their kid here young enough and grew up here gets a pass while their counterpart who grew up in the country they fled from doesn't get a pass just because he's here and not there. It's like, that doesn't seem fair to the person who's there and not here. So it's like, I just think we should have rule of law and it should be fair and equitable. And the cure for the crapshoot of it all is not to like make it more crapshooty. It's to try to fix it and make it less crapshooty, more systemic. I don't know. That's kind of how I feel like that. There's never been a criminal defense attorney appointed to the Supreme Court. Okay, noted. That's fine. So anyways, that was a very long discussion on immigration policy. I hope you liked this stream. I hope you liked the latest version of Supreme Court React. If you liked this stream, I would appreciate it if you gave us a thumbs up. 13 of you have given a thumbs up. There's 27 people watching the video right now. So I'm just saying, 14 of you could give me a thumbs up. That would be nice. But if not, I understand too. And, feel free to leave a comment, subscription, all the rest of it. And, I always appreciate it. Evil Coleslaw says, I hope I'm going to do more collaborations with Nate. I do too. I really like Nate. I think he's a very interesting guy. And I meant what I said on stream. I meant that, I really hope that we can build some sort of LawTube community. And so, like, you know, I have a good relationship with Leonard, of course. You know, I'm hoping to build a good relationship with Nate. I'm hoping that relationship opens up a relationship with Viva Fry. You know, I'm hoping that opens up a relationship with other YouTube lawyers, and I'm hoping that we will, you know, maybe have LawCon someday. So, you know, I'm really hoping that this can be a thing, and we'll have our own little, like, you know, thing over here, and we can, you know, we can respond to each other. We can film videos of each other, because it's good to get different legal thinkers, different legal people who think about things differently and can express things intelligently and express multiple points of view. And as I said, try to come up with one coherent opinion. So, you know, that's, you know, for the good for it. So it's like, yeah. So, you did not temporarily dislike the video, I promise. Thank you, Nicholas. I appreciate that. Thank you for schooling us. I don't know if I'm schooling you necessarily. Well, I guess I am a little, but, you know, I'm here to try to educate about the law, try to educate about opinions, try to listen to this and react to it in real time, trying to, like, highlight various things that I think are right or think are wrong, or find weaknesses or strengths of argument. So, like, of course, it's all being biased by me, but it's like, well, you know I'm biased, so at least I, you know, try to, like, say where I stand on things, so, you know, you understand my philosophies. And so, yeah, I appreciate the love as always. Juwan says, thank you very much. It was informative as always. Epstein didn't kill himself. Yeah, you know, I've said this before, and I'll say it again. You know, when it comes to Epstein, I think there are 4 possibilities. Possibility 1 is that Epstein actually killed himself. Possibility 2 is that Epstein was helped to kill himself. Possibility number 3 is that Epstein was murdered. And possibility 4 is that Epstein is actually still alive. Of these 4 possibilities, the one that Epstein actually just randomly killed himself seems to me the least likely. And that's saying a lot when one of those possibilities is that he's still alive. So yes, I'm also skeptical of it. It doesn't make any sense. It was the first suicide in that prison in what, like 23 years or something like that. It's one of the most, it's a secure prison. They've had high profile people. He was high profile. He had a previous suicide attempt. You think that would capture their attention? It's like, and the cameras weren't working, all this stuff. It's like, you gotta be kidding me. Really? Like, it's like, you know, I'm as willing as the next guy to assume incompetence, you know, rather than malice. There's a great, what is it? Is it Occam's razor or one of those razor ones? It's like, you know, all else being equal, assume incompetence rather than malice. But man, oh man, there's a lot of incompetence if it's just pure incompetence. It's like, you knew he was a suicide risk. You put him on suicide watch. You took him off. He was supposed to have someone in his cell. You took him away. You know, the things were supposed to be working. They weren't. Both guards fell asleep at the same time. I'm like, Lord have mercy. How much incompetence can we style up? I mean, again, you know, I'm skeptical of the government. I'm skeptical of government power. I'm willing to, like, say that people can be incompetent. But man, that is a lot of incompetence, again, in a prison where they haven't had a suicide in like 23 years. And he's the first? This guy who's super high profile? Man, it's like, that seems to me just like ridiculously unlikely. Personally, I think the most likely scenario is that he was assisted along in his suicide. I think that, you know, people, like, purposely looked the other way, purposely encouraged and purposely supplied him. So, like, that's kind of my most dominant theory. I tend to think the facilitated, he was helped along on his suicide rather than just outright murdered is my personal bet on the working theory. But, like, yeah, he just decided to commit suicide and somehow managed to accomplish the means, even though, like, all these factors were against him. Is like, you know, I just don't think so. It's like, I mean, come on. It's Hyland's razor, not Occam's razor. Thank you. So yes, like, that's kind of like what I thought. And so, yeah, so that's kind of what I think is that they suicide with assistance. And if you want to say that you don't think that's the most likely, and you want to say that he was murdered, I don't blame you. That's just a personal opinion. You know, I could be wrong. Murder is not out of the question. So, you know, I'm going with a facilitated suicide as my working bet. But, you know, I could be wrong. But, like, just random suicides, like, I don't think so, man. It's like, eh. So that's how I feel about that. Someone said he was Clinton. Damn, maybe. Nightbot. Yeah, I will try to fix the Nightbot issue. I'm sorry, Juan, that it keeps helping. So I'll try to fix that so that doesn't keep happening. But yeah, like he just up and committed suicide somehow, had the means to do it. It's like, man, I don't know, man. Like, how much suspension of disbelief do you really want me to have? It's like, I don't know. So I don't know if anyone's still investigating. I've heard rumors the FBI investigation has stopped for no reason. So like, that's real super encouraging. And like the medical examiner like put a little bow on it. It's like, I don't know, man. That's a lot. I'm not normally conspiracy theory minded. I'm again, normally I'm very willing to accept incompetence, but I don't know. That's a lot of incompetence, even for the federal government. That's a lot. So it just seems too much. So yeah. So that's kind of how I feel about this. Anyways, that was a nice little diversion into the Epstein stuff. So like, so that's what I think. So anyways, why they skip some of the transcript on the audio? Oye codes it. So it's probably just a coding error from Oye. Or more likely, like the audio didn't quite pick it up, because sometimes you'll like hear a justice in the microphone. They didn't like turn on the microphone, so like it may not just be audible to you because it was there, but not really super audible. So either it was a coding error or Oye is actually picking up on something that didn't quite broadcast or stuff like that. So that's what happened. Anyways, I hope you like the stream as always. I will be on this weekend as always with more stuff, and as always, I'll be here for your comments. You can find me on Discord on Lawful Masses under the name Blackleaf. You can find me on Facebook.com on Civil Law, and as always, please like this channel. Tell your friends about it. We seem to be growing. I think we've got 2,100 subscribers now, so that's nice. Things seem to be growing along. And until later, my friends, I am out. Cheers and goodbye.